Hi there. Can you let me know who you are? I can't quite see your face and I don't know your name.
Good morning.
I'm sorry?
Good morning.
Hi.
Oh,
Can you let me know your name? I can't quite see, I can only see your eyes.
sorry. My name is Marie Nero. I'm from Shaw's Supermarket.
Okay, great. Yep, got it. Okay, thank you.
No,
I'm going to keep it on mute.
perfect. Thanks.
Hi there, John W. Are you John Williams? Nope, you're not. Nope, you're still muted. Still muted. John Walton. Okay. Hi there, James. Just wondering if you can let me know your last name and what case you're here for. Nope, you're muted.
Are you talking about James Sanoski?
No, I'm not. I'm talking.
Okay.
We have a new James.
Okay.
Thank you. Nope, still muted. It should be about. There you go.
Can you hear me now?
Yes.
Okay. My last name's Williams.
Aha. Perfect. Thank you. I'm going to keep you muted for now.
All right, thank you.
Hi, whoever just joined us on a phone line ending in 914, can you let me know who you are, what your name is? You'd have to unmute first.
Good morning, Nick Eubster, Deputy General Counsel with Insight Health Corp.
Great, thanks very much.
Thank you.
Hi, we have a couple folks that are just joining us by phone only, and I'm hoping you can unmute and let me know your names.
Hi, Amy. This is Alice.
Hi, Alice.
I'm having problems getting in on my computer right now, so I just called in.
Okay, thanks, Alice.
Yep.
And we have someone whose phone number ends in 514.
Hello?
Hi.
Hi, it's Deborah Libby.
Okay, thanks very much for letting me know. I'm putting you back on mute. Thank you.
Okay.
Hi, Ed. How are you?
Good morning. How you doing?
Good, thank you.
Thank you for that answer about the education. I knew it had to be something like that.
Yeah, I'm sorry I forgot to
Yeah.
send it earlier.
No, I was thinking that there had to be some jurisdictional thing.
Yes, exactly. We're still collecting people. I think we need one more commissioner. I'm expecting Commissioner Ashby. I think Commissioner Hellberg can't join us today. And I also don't see the folks from, well, I see, yeah. So just waiting on a few people.
Okay.
Hello, Commissioner Ashby.
Good morning. How are you? Boy, that was touch and go. I almost didn't make it.
Really?
Computer.
Where you been?
I've been right here, but my computer didn't want to take me to you. Here I am.
I'm glad that you got it, beat it into submission. Okay, do we have 3 commissioners? 1, 2, 3. Okay, that's what we're going to have for today. A small quorum. Commissioner
Good
Whitworth.
morning, everybody.
Yep, there you go.
I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who has an electronic device, which is all of us, cell phone, pager, etc., to ensure that they're silenced. We have agendas that are available online on our website, including the consent agenda. The consent agenda is a listing of cases in which no written arguments were made to the commission, and we will vote on those cases, and they will not be considered further today. So with that, we can start with the adoption of the agenda and the consent agenda. Is there a motion to approve?
Nope, hold on, before we make a motion, I need to present to commissioners a matter that came up Friday afternoon because it would change the agenda if it were granted. There was a request from a complainant whose case is on the hearing agenda today. The request was to withdraw their complaint.
Yeah.
And because there wasn't time to upload it, I sent you all an email providing you the memo from the complainant, explaining what the complainant's reasons were for wanting to withdraw. And there was also a bit from the respondent's attorney and I gave you my recommendation. And before there's any adoption of the agenda, I would ask that you address the request and either grant it or deny it.
Is there a motion? Yes. Ed?
Yes, I'll move that we deny the request to withdraw.
I will second that. All in favor?
1, 2, 3. So the motion is denied. Okay, with that out of the way, it would be great if someone would make a motion to adopt the agenda and the consent agenda.
So moved. We adopt the agenda and the consent agenda.
Second.
All in favor? Raise your hand, say it. Yes.
Aye.
Right.
Thank you. That's passed.
The minutes from our December 13th, 2020 commission meeting. Is there a motion to either approve or amend the minutes as submitted?
I'll move to accept the minutes of the December meeting as submitted.
Second.
All in favor?
1, 2, 3.
Unanimous.
Thank you.
Yeah.
Great.
Thank you. And let's move to the director's report. Amy?
Yes, good morning. Let's see. So starting with, you do not have a memo from me regarding administration or personnel. There have been no personnel changes, so you don't have a memo. Next, for compliance on the status of reasonable grounds cases, you do have a memo. That shows you that there are 9 cases currently in active conciliation. In the past month, we did not have any successful conciliations. We had 1 unsuccessful conciliation. We don't have any conciliation agreements for you all to review as far as I know. Next, for investigation, in December, we received
Question,
yes.
Amy.
Sorry, yes.
Being still a little bit new, is conciliation the same as mediation, and how is that
No.
track decided?
That's a great question. So They are and they're not. So the difference is conciliation happens after the commission has found reasonable grounds to think that discrimination happened. At that point, we are required to try to get the parties to sit down and reach an agreement. So it is essentially a mediation, but it is different than what we call our mediation program, because our mediation program happens before there's been any decision about a case, before we've even assigned it to an investigator.
So it's before a report,
Yes, exactly.
and it's voluntary
Absolutely.
by the parties, right?
Completely.
Okay.
It's so voluntary, people have to pay for it. Yeah. So we had 26 new complaints filed in December. And in December, I administratively dismissed 12 cases. And for predetermination settlements, and this goes to your question, Ed. So this is before there was any report on a case. So when cases were still midstream for us, in December, there were 14 predetermination settlement agreements, and some of them might have been through our mediation program, some of them might not, with benefits of about $460,000 to complainants. So next, on to quarterly reports. So you all have a memo from me outlining, outlining about 17 training and education events that our staff took part in or delivered in the quarter. You also have a financial report from Melody Piper that includes, there's a second page, a supplemental quarterly report for certain expenditures that we are required to track under OPEGA. It's a quasi-judicial, quasi-independent report that we do several times. Once a year, where actually it's come up again. It's time to do that again, and we give you supplemental reports. I think for quarterly reports, that's it. Oh, sorry, that's not it. Also, pending inventory. As of now, we have 669 cases pending at the commission. The age overall for all cases, regardless of what stage they're at, is about 241 days. And then if you add on the average age a case with an investigator is, that's about another 180 days. So that is the quarterly program review. For new business, the legislature is getting back in the swing of things. We did submit one bill, which is essentially the same as the bill that died on the governor's desk at the end of last session. And we also, we will be going to, every 2 years, we go and introduce ourselves again to the Judiciary Committee, our committee of reference. We'll be doing that on the 21st. And we did see how the governor's proposed biennial budget fared for our agency, and so far looks pretty good. There was not a proposal to cut staff from us, and that's a huge relief since we're pretty small already. Yeah. Also just wanted to mention that we did close out one HUD grant, which is good news. They are always challenging. We have 2 others that we are still working on, one of which relates to doing outreach and education for shelters and transitional housing. And the other relates to COVID, and that grant arose out of the CARES Act for agencies like ours around the country. And you may have seen, I think I forwarded to you the public service announcement that we created. It's gotten lots of eyeballs on it. We're also working on creating a longer educational video about how COVID and the Maine Human Rights Act might interact. And in a delightful turn of events, we worked collaboratively with the Office of the Governor regarding providing information about COVID and the Maine Human Rights Act on our website. So that is a delightful collaboration and change of pace for us. And that's all I have for new business.
We can take a 5-minute break then, and we'll come back at 8:45 and work through our cases to be heard.
Thank you.
Good
Hello?
morning, Kim. It's Bob Boots. How are you?
Okay, it's 8:45, so let's get started here. So the remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions and audio submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and please introduce yourself as you are given the mic, so to speak. Thank you.
And I would also ask folks not to use the names of any third parties or witnesses. We have, unless you have named them as a respondent, do not use their name. We've given everyone pseudonyms in the reports that we sent out. And I would also note we have a pretty long agenda, so I would ask folks to try to keep it brief.
So the first case on our agenda is a reasonable grounds case.
Actually, Deb,
Yes.
we were going to take one case out of order,
Oh, that's right.
that we were going to take the last case first.
Yes. So, H, it's a housing case, H20-0372, -A-D. So Heidi Theberge, the Lewiston Housing Authority, Carla Harris, Chris Kilmurray, and Travis. Is there anybody here for Lewiston Housing Authority?
No,
Or-
this
Yes.
is this is a no reasonable grounds case.
Oh, I'm sorry. You're right. No reasonable grounds. Is there anybody here for Heidi Theberge? Given that, is there a motion?
I move that we adopt the findings of the investigator and find that there are no reasonable grounds to believe that respondent discriminated against complainant on the basis of disability, and no reasonable grounds to believe that respondent retaliated against complainant for asserting her rights under the act, and that the complaint be dismissed in accordance with the act.
Second.
All in favor?
Oh, hold on. Any discussion? Hold on.
Oh, I'm sorry.
Moved and seconded. Is there any discussion?
I'm clearly not good at this.
You're great. Okay. Seeing none.
Since
Wanna
there's
call
no
the question, Deb?
discussion?
Yeah.
All in favor?
Aye.
So the vote is 3-0. The findings are both no reasonable grounds.
Thank you.
Okay, now we will go back to our agenda. Ann Varney, the Planet Fitness is, and since this is a reasonable grounds case, is there anybody here for Planet Fitness?
Yes, this is Jeremy Walker from McLean Middleton, and I am here on behalf of Planet Fitness Maine, which was the entity that owned the facility at the time. And Mr. Glidden, I believe, is on the phone as well, who was the owner at the time.
So again, I appreciate you letting us know. After that, it would be best not to use the names of any witnesses or third parties because he wasn't named individually. Obviously, he's here, so.
Thank you for that reminder.
So then Respondent has 10 minutes to present.
Well, thank you, Ms. Sneerson, and thank you to the commissioners for the time for being here. As I mentioned, my client is Planet Fitness Maine, which was a small business, former owner of the Planet Fitness franchise facility in Auburn, Maine. It also owned 2 other facilities, but it no longer owns any of the facilities, any of the Planet Fitness facilities, and is not affiliated with Planet Fitness. So during the course of the ownership, this was the only claim of discrimination of any type brought against one of PF Maine's facilities. The complainant felt that she was not treated fairly by manager of the Auburn facility, by the manager at the time of that facility, and noted during the hearing with the investigator that she and the manager clashed about whether her resume was uploaded properly to the online system that Planet Fitness used. Planet Fitness used a variety of online services, and Planet Fitness receives a number of applications online. In any event, when the claim was brought, Planet Fitness Maine and its owner denied it vehemently, and the owner interviewed and worked with the facility manager to understand why the complainant was not hired, and determined himself that he felt that there was no discrimination whatsoever based on her age. The complaint was filed back in January of 2019, and then the investigator held a fact-finding conference in September of 2020, so which was a year and about 8 months after the complaint was brought. So at that time, and this is what's critical, Planet Fitness Maine no longer owned that facility, could not access all the records at the time the hearing was held. But more importantly, the former manager of the facility that made all of the hiring decisions no longer worked at that facility, nor could she be contacted despite a number of efforts by us to contact her. And even the investigator was trying to, I believe, was trying to contact her as well. So at the fact-finding conference with the investigator, or Planet Fitness Maine was unable to have the testimony of the manager who had been employed over 18 months earlier when the claim arose. So Planet Fitness Maine, my client, argued that naturally, a lot of younger applicants apply to Planet Fitness just due to the nature of it being a health club and a gym where there are a lot of young people there working out. Resumes are taken online and then reviewed for shift availability. That's one of the primary issues, is whether the applicant can work one of the 3 shifts, because it's a 24-hour facility. And in this case, when the complainant applied, the shifts she wanted were not available. And when those shifts became available, as is typical, the facility then would first fill with existing employees who were looking to move from one shift to another. The complainant disagreed, and the investigator made his findings, and Planet Fitness Maine objects to the investigator's finding in particular, that other younger individuals were hired for the exact position that the complainant had been hired for, with his conclusion that it was largely irrelevant that employees it hired later moved to different shifts or different positions. We disagreed with that completely, because when we looked at and we provided as much evidence as we had at the time the complaint was filed at the different shifts and how they were filled by existing employees who, if they'd been working the night shift and they wanted to work the day shift, they would naturally be moved in there first. But in any event, and to wrap up here, when the investigator issued his report on December 8th, 2020, one of his recommendations, as we understood it, was that conciliation should be attempted in keeping with the particular Maine statute. So although my client disagreed with the finding of discrimination, we immediately reached out to the complainant to understand what we could do as a form of conciliation. And of course, my client no longer owns that facility, no longer owns any Planet Fitness facility. But the complainant explained that she was no longer interested in employment at Planet Fitness, had already obtained employment elsewhere after the time she issued the complaint.
Mr. Walker, I'm really sorry to interrupt you, but this is not in the record. Whatever conversation you had with the complainant, that happened after the report. So that's really not something, whatever that conversation was, the investigator didn't get to consider that.
I appreciate that. I guess this is just in the investigator's finding. There is the recommendation that conciliation be attempted. And I thought it was important for the commission to know that that is why the conciliation occurred, or the attempt at conciliation occurred the way it did. And frankly, when we reached out to the complainant, she acknowledged, and I don't think she's on this, I can't tell, but it doesn't appear that she's on it, that she appreciated that her voice was heard.
Mr. Walker,
Yes.
again, I understand that you want the commission to know how you got to this place, but what you're describing is a conversation that happened after the record closed. So it's
understand.
not something the commissioners can consider.
I appreciate that. So for purposes of then our major disagreement with the investigator's report is the conclusion of how her position was filled, and the fact that we disagree that it's his finding that it's irrelevant whether it came from other shifts and such. So I'll wrap it up with that, and thank you for your time.
Commissioners, question for Mr. Walker. Commissioner Whitworth,
No questions, thanks.
Commissioner Ashby,
I think I have no questions. Thank you.
Commissioner David.
No, thank you.
Okay, I'm going to mute you for now, Mr. Walker.
Is there anybody here for the complainant?
Ann Varney. Is Miss Varney here? I didn't see her on here either, but. And the investigator is shaking his head.
No, okay. Then we can hear from the investigator.
Hold on, one sec. I just wanted to ask Mr. Walker, do you have anything else? You have 5 other minutes if you want to use them.
No, I don't. Thank you. I would be happy to take any questions or any comments from the investigator, but I don't have anything further to add.
Okay, thank you. Okay, then it's Bob.
Morning, commissioners. Just to cover a couple of points in this case. Number one, respondent's position or explanation for why complainant was not hired was that there were no first and second shift positions in the MSR position she was seeking around the time that she applied. In fact, the hiring roster provided by respondent indicated that at least 6 different applicants were hired for part-time MSR positions during the time or around the time that complainant had applied in this case. Respondent also asserted that 2 of those 6 individuals were hired because they had greater shift availability than complainant. Based upon their applications, however, only one of the successful applicants offered to work 3rd shift, and of the remaining 2, they listed the same availability as claimant, and 2 of them actually listed more limited availability for shifts, and they ended up being hired. Lastly, they also indicated that one of the 6 individuals hired was hired because he had prior experience at a gym, despite the fact that his application lists his sole employment history as 5 years working for a cleaning company. In this particular case, there was a dispute in facts about whether or not complainant, in fact, attached her full resume to the 2 applications that she made. However, in any case, even assuming that the full information was not provided, the information she did provide listed at least a bachelor's degree in physical education, which would appear at least on its face to make her more qualified for a gym position than would somebody whose exclusive employment history was exclusively in cleaning. So again, in this particular case, and I understand the respondent was somewhat hampered by the unavailability of the manager, but the record in this case clearly reflects that individuals were hired for the exact position the complainant had applied for. So there were clearly, they were hiring at the time. I guess just lastly, of these 6 individuals hired, aside from one who was age 35, 4 of the remaining candidates were in their 20s, and the last one was 19 years of age. So in my estimation, this brought complainant at least up to the reasonable ground standard of at least an even chance of prevailing at trial, which was the basis for my reasonable grounds recommendation.
Commissioners, any questions for the investigator? Commissioner Whitworth?
No, I don't have any questions.
Commissioner Ashby?
Yeah, I have just a couple. First of all, am I wrong to see that your report doesn't reflect what the complainant's age is?
Well, again, I don't, it was contained obviously in the complainant's charge with the commission without identifying her specific age. I can safely represent that it was substantially older than even the oldest of the 6 applicants that were hired.
Hello?
Hi, we're in the middle of a presentation. Can I ask who this is?
Heidi T-Bridge. I've been trying for the past 15, 20 minutes to get through for my appointment this morning.
Yes, Mr. Burge, I'll be back with you in just a minute. Can you just hold on, please?
Yeah, I'm just getting all confused.
Yes, can you hold on, please? We're in the middle of another case.
Yeah.
Sorry, go ahead.
Okay. Is there a reason why we don't learn the age of the complainant in a case such as this, or in this particular case? I'm not so new to this that I should know the answer to that, or that I shouldn't know the answer to that, but I don't.
Perhaps I should leave that one to Commission Counsel. Unless there's
Council may not have, I think Commission Counsel possibly may have been looking at the message I'm sending her and did not hear the question.
Yeah, sorry, Jeff. Not putting in the age was perhaps an oversight. It was pled, it was in the complaint. Normally we would put it in. I suspect it was an editing error.
Okay, no, that's fine. I just want to make sure that that I'm not missing something. And secondly, the wording on page 4, paragraphs 8A and B, explain this addressing the pretextual argument by the respondent, explain that the complainant was told that first and second shifts weren't available, and that the assertion was directly contradicted that at least 6 different applicants were hired for part-time positions. Were they actually hired for first and second shifts?
Again, as noted, they were they listed their availability on their applications, and as I indicated, the claim was that the complainant was not hired because she was not as flexible with their shift choices. However, again, only one of the 6 individuals hired offered to work the 3rd shift. One listed the exact same availability that she did, first and second shift, and 2 listed only a single shift availability. So the argument that it was her lack of flexibility that resulted in her non-selection simply wasn't borne out by the record.
Well, I think that gets us there, but and so I think the argument to counter the claim of the argument that this is pretextual is that they listed the same availability as she did, and they were offered positions. It's not entirely certain that they were given positions first and second shift, but at least, are you suggesting that at least the complainant should have been offered employment?
Well, again, that wouldn't really be my call in this particular case. I would point out that respondents' argument was that the last time that complainant checked on whether her application had been received, the manager of the facility initially claimed internet difficulties, and then once the internet was restored, claimed that she took a quick look, saw it was only first and second shifts, and told her at that time that she was not going to be hired because that was limited availability. So the fact that they brought other people on board that listed the exact same availability or even less availability simply against that argument.
That clarifies things. That helps because that, as I understand it, I think I hear the respondent saying that in actuality, the people that might have listed first and second shifts, as did the complainant, they may well have not been put in those shifts. And I think the respondent thinks that absolves them. But as I understand it, it's that the complainant was disregarded, unlike the other folks, despite the fact that she listed the same shifts as being available.
And as I noted in the report, it's certainly possible that there were oral discussions with those successful applicants in which they indicated further availability. Unfortunately, complainant was never allowed that opportunity because no conversation ever took place with her about whether or not she might have been willing to work other shifts. So I had to go by what they listed on their applications as far as desired shifts. And as I said, in most cases, she had equal or greater availability than the individuals hired.
Right. That's actually very helpful. Thank you very much.
Mr. David?
Yeah,
Questions?
I had exactly the same question as about the age missing, and you've answered that. I also understand, do I understand, Bob, correctly, that a part of what you're indicating is pretextual is what you're concluding is being given the runaround colloquially about the application, right?
Well,
that
again,
it's not there. It's I can't find it. Got to do it again. It needs to be paper. It doesn't need to be paper or whatever.
certainly that added to complainant's frustration. She applied originally for whatever reason, and she concedes it may have been in fact her error, but essentially it wasn't listed as complete. However, when she applied the second time, she received actual confirmation that it had been received. So I think it was at that point, she apparently checked back with the manager again to see whether or not the second application had been received. And that's when the manager allegedly took a quick look at the computer and, indicated that it was because she only indicated first and second shift. Well, she didn't tell complainant that, but that was her explanation. She checked the computer, saw that she was only willing to work first and second shifts, and that was why no interview was ever provided.
Okay, thank you.
Okay, so we've heard from a respondent who does not have another opportunity to present. And the investigator. So at this point, we would be looking for a motion or motions.
I'll move that we find that there's reasonable grounds to believe there was discrimination on the basis of age and conciliation should be attempted.
Second.
All in favor?
Well, hold on. Any discussion? Nope. Gotta have discussion.
Sorry.
I need discussion.
Briefly, I guess, I think that the respondent's argument that the actual placing of the successful applicants into shifts that might have been different than shifts 1 and 2, the ones that complainant were seeking, that argument is probably misplaced in that it looks like it's the offering of employment generally, or even the following through with the application for the failure to do so with complainant was the discriminatory act. She wasn't even given a shot. As Commissioner David indicated, it was a bit of a runaround, and it's certainly an even shot that this complainant can show that that was on the basis of age.
Any other discussion?
Yeah, I mean, it seems to me that often these cases we have a comparison with the one other successful applicant and a comparison of the two ages. Here, it's fairly clear that when you have 4 other people in their 20s or teens that were making out an equal, as likely or not that there's discrimination. So I don't have any problem with that finding at all.
Okay, that having been said, so the motion is to find reasonable grounds to believe that unlawful discrimination occurred. All those commissioners in favor of the motion, raise your hand and say aye.
Aye.
One,
Aye.
two, three. The finding is reasonable grounds. The commission will be in touch with the parties by letter. Thank you. Now, the person who just called in is the complainant from the first case that was called. And I know you're on there, Mr. Burge. We did hear your case at 8:45 as promised, and the commission did decide the case. I understand that you were having trouble getting into the call. So the investigator has already gotten off of the meeting, as have the respondents and the lawyers for this case. We are trying to get in touch with them to see if they can come back. I see actually Respondents Council is just coming back. Mr. Lamori, thank you for jumping back on. We are trying to figure out right now. We don't have the investigator at the moment. Commissioners, I think the first question for you, commissioners, is if you want to reconsider your findings. You voted on the case at 8:45. I will tell you that I did speak with Mr. Burge Friday afternoon at some length about how to call in and if you wanted to be the first case on the agenda or not, and she did. And if she wanted to call in versus me having call her, and she did want to call in. So I think the question for commissioners first is, do you want to vote to reconsider and allow the complainant to present her objection to the investigator's report?
Yes.
I would agree if we can reassemble our team. I want to hear from the investigator, but I want her to feel that she has been heard, if that's possible.
So, Ms. LaBerge, we're not asking you to do anything right now. So right now, we're trying to see if we can get our investigator back on the line.
Okay.
So don't do anything yet. If we can get the investigator back, then we can go ahead and hear your case. And Mr. Lamori, thank you for jumping back on.
Sure.
What I recommend, just so we don't lose time, we have a lot of cases, I recommend that we do the next case while we are waiting to see if we can get the investigator back.
The
Does that make
investigator has acknowledged and is trying to come back. She's having some connection problems and will be here as soon as possible.
Yes. Okay, thank you. I recommend that we do the next case on the agenda while we're waiting for the investigator to come back. So that means Mr. Lamori and Mr. Burge, what I would like for you to do is just wait until we can get the investigator back. Okay?
Understood. Thank you.
Thank you. And Mr. Burge, I'm going to mute you on here. Are you able to unmute yourself when I tell you it's time?
Yeah.
Okay. Hang on. Okay. Okay. So, Commissioner Whitworth, I recommend that you call E190149.
So Autumn Dinsmore v. State of Maine Department of Corrections, Maine State Prison. This is a reasonable grounds case. Is anybody here for the respondent?
Yes, good morning, commissioners. My name is Kelly Morrill, Assistant Attorney General. I'm here for the Maine Department of Corrections.
Okay, 10 minutes, counsel.
Thank you. The department respectfully disagrees with the recommendation of reasonable grounds on the sex discrimination and the hostile work environment based on sex claims in this case. So first, with respect to the sex discrimination claim, the report does not find that the department disciplined the complainant for things she didn't do. Rather, the reasonable grounds recommendation is based on the finding that the complainant was treated differently than male correctional officers with respect to the issuance of discipline or the level of the discipline that was issued. But that finding doesn't take into account the principles of progressive discipline, the severity of the conduct, and the fact that Ms. Dinsmore was investigated and disciplined 3 times within 3 months in 2018 for crossing boundaries. 2 of those investigations involved the same prisoner. In the first investigation, Ms. Dinsmore was found to have spent 80 minutes out of 130 minutes talking to this prisoner during her shift. Now, the department does not dispute that correctional officers talk to prisoners, that they do that as part of their jobs, but extended conversations are not allowed and create potential safety issues for both the correctional officer and the prisoner. Ms. Dinsmore received a 2-day paper suspension as a result of that first investigation, which is essentially a written reprimand in lieu of a suspension. She did not grieve that discipline with her union. During the second investigation, Ms. Dinsmore was found to have let that same inmate from investigation 1 into her pod on 3 different days in the course of 1 week, May 2nd, 7th, and 8th. Now, the department has a policy that says that inmates are not supposed to travel between pods. They're supposed to stay in their own pod. After the second time on May 7th, the sergeant spoke with Ms. Dinsmore and told her that prisoners were not supposed to visit pods to which they weren't assigned. Despite that conversation, she allowed the same inmate into her pod on May 8th, the next day. Following an investigation, she again received a 2-day paper suspension for that. And she didn't grieve that discipline either through her union. The third investigation was in June of 18. That involved Ms. Dinsmore contacting a former inmate and also for accessing his contact information on CORIS, the Correctional Information System. So she had alleged after that this inmate was stalking her. So she accessed his home contact information on CORIS, called him at his home, had one of her friends call him at his home. His wife called the Department of Corrections to complain that a correctional officer was calling her husband. The department investigated, and as a result of that investigation, she got a 2-week unpaid suspension. She did grieve that suspension. Now, she did not report the stalking to anyone in management at the prison until after she was served with a notice of investigation on that. It was the day after she was served with the amended notice of investigation. And quite a few members of management were interviewed during that investigation and all said that she had not contacted them prior to the investigation starting about this stalking. So during this investigation at the commission, the department did submit an Excel spreadsheet that listed all disciplines issued to correctional officers at the prison from April of 2017 through May of 2019. That was exhibit 32 of the department's original submission in June of 2019. The list reflects that in 2018, 2 male correctional officers received 40-hour unpaid suspensions for similar type behavior, crossing boundaries. Although that list is de-identified, it does list the gender of the correctional officer, it lists the conduct engaged in, and it does list the date. And if we look at that list reflects that those 2 male correctional officers did not have any other discipline for similar conduct, at least between April of 2017 and March of 2018, the date they received the 40-hour suspensions. And in the investigation report, the investigator uses those 2 as comparisons to find that Ms. Dinsmore's 2-week suspension was too harsh and that she was treated differently based on her sex. And the department's position is she was not treated differently. The department just took into consideration that she had previous disciplines in her file already for the same type of conduct. Ms. Dinsmore also received the 2-day paper suspension in 2019 for attendance issues. That discipline list also reflects that at least 11 male correctional officers also received 2-day paper suspensions for attendance type issues during that period of time. With respect to the hostile work environment claim, the department disputes that the conduct rose to the level of severe pervasive conduct. We don't dispute that there were some comments made about women working at the prison. We don't dispute that it's inappropriate to make those comments. However, we do dispute that it rises to the level of a hostile work environment under the law, severe or pervasive. There's also evidence in the record that the correctional officer who was identified as making some of those comments was given a written reprimand for that. There was also another correctional officer who was given a written reprimand based on Ms. Dinsmore's complaint that he had divulged personal information about her to an inmate. He was disciplined for that. So the department's position is that it took immediate and appropriate corrective action with respect to the conduct that it knew about. I think that's all I have. I'm happy to answer any questions the commissioners might have at this point.
Thank you. Just make a note. Commissioner Whitworth, any questions for Ms. Morrell?
Not at this time.
Commissioner Ashby?
A couple. I just want to clarify, the 2-week unpaid suspension was a response to the complainants accessing the respondent's database to obtain, and then to reach out and have personal contact with one of the prisoners. Is that correct?
Correct. He was a probationer. That's correct.
And I note the investigator reports, and I don't really know how relevant it is to the issue, but the investigator points out that the respondent has no policy regarding what to do if current staff is being harassed or stalked by a former prisoner. Is that true?
I'm not aware of one. It's not in the record, but I'm not aware of one. I believe they after she was put under investigation and she said she was being stalked, they had referred her to law enforcement, which she had already done, and she had attempted to take out a protection order against this person, and it was denied by the court.
Okay. Just in the timing of things, your response indicates that the complainant only notified her superiors of this stalking by a former prisoner after being confronted with her accessing this database. Is that correct?
That's correct. Yes.
But by that time, she actually had reached out to law enforcement, or did she reach out to law enforcement only after conversations with the superiors?
I think the record is a little unclear about that. I think there's a dispute as to actually when she reached out. I believe the temporary protection order was dated after she was put under investigation. I believe it was July 1st. I'm not 100% sure of that, but I believe it was around July 1st. And Ms. Layton can correct me if I'm wrong about that.
Okay, thank you so much.
Thank you.
Commissioner David?
Ms. Morrell, I'm looking at that same issue that Commissioner Ashby was at the time that she's claiming that she's being stalked. The prisoner is still under probation and still under the jurisdiction of the department, is he not? He or she?
That's correct.
Okay. And it does strike me then that for them to say, well, call the cops, there's nothing we could do, is not paying sufficient attention to it. How do you respond to that?
I think things could have been done differently at that point. I believe she did report it after she was put under investigation, but when she did, things could have been handled differently, possibly.
Thank you.
So you'll have, thank you. You'll have 3.5 minutes, Ms. Morrell, after we hear from complainants counsel. And I believe Ms. Layton, is that you?
Yes. Good morning. I'm Shelby Layton, representing Officer Autumn Dinsmore, and she's also on the call today. So I want to respond to a few points that Kelly made. So first, I want to note that Investigator Thompson-Crossman had the benefit of an in-person issues and resolution conference in this case before all of this happened and everything went remote. So to the extent the state is disputing their factual findings, for example, the timing of when Autumn reported the prisoner or the probationer stalking her, or whether she used the computer system to find his contact information. I really urge the commission to defer to the investigator's findings because they were able to do an in-person assessment of witness credibility. Second, the investigator correctly focused on the fact that it's not whether Autumn broke the letter of prison policy, but it's whether her behavior was placed under a microscope and scrutinized, and whether she was singled out for discipline, either more harsh discipline or just receiving discipline at all when her male colleagues did not. So the two most egregious examples of this are that when she was disciplined for letting a prisoner into her pod without a supervisor's approval, but the way that system works is that another officer has to send the prisoner to her pod, and that officer admitted to doing that and wasn't disciplined at all. And then also, in terms of the scrutiny, I think it's really important to point out the context in which she was reported for being overfamiliar with the prisoner, which was that a group of male officers whose sexist comments she had opposed only a few days before spent an enormous amount of time watching the video of her conversation, listening in on her conversation with the prisoner to try to catch her in a moment of sharing personal information. And really what she was trying to do was get the prisoner to apply to college and sharing her personal experiences with college. But, they were watching her and waiting for her to say something so that they could report it. And that's exactly what they did. And the prison went so far as to watch videos of her conversations and count the number of minutes that she spent talking with the prisoners. But the other officers who admitted to talking with the same prisoner, who was described as being, kind of a chatty guy, and who other people admitted to talking to, they never had the video of their conversations with him scrutinized in the same way, or the minutes that they spent talking to him counted. And then when another male officer did actually share sensitive personal information about Autumn with a prisoner that led to him calling her a homophobic slur, that officer was disciplined less harshly than Autumn was for sharing innocuous information with a prisoner. And note that was only the second discipline that Autumn had received, so it's not like she had a long history at that point that would require them to give her harsher discipline. And then this disparate discipline is part of a larger and pervasive attitude at the prison that female officers shouldn't work there because they can't be trusted not to have sexual or romantic relationships with inmates. And that attitude is manifested in statements by at least 3 different officers that women should not work at the prison. An officer asking Autumn when she first started working at the prison whether she was there for love or a lawsuit. Comments by male officers that female officers are always getting into trouble, or having relationships with inmates, and a male officer telling a new officer that Autumn had a quote unquote bad reputation and implying that she had a relationship with an inmate. And then I also think it's reflected in the state's continued insistence that this discipline was necessary because it was concerned about violations of the Prison Rape Elimination Act, and because Autumn was quote unquote crossing boundaries. And the same assumptions and scrutiny about someone having a long conversation with an inmate was not applied to the male officers. And then finally, I just wanted to focus on the standard for a hostile work environment claim. The state is wrong in its written materials to suggest that Autumn needs to establish that the behavior was quote unquote extreme. The legal standard is severe or pervasive. And here Autumn has shown a long and pervasive environment of offensive, belittling, and demeaning comments about female officers. And those can be taken together with the complaints about her behavior by other male officers and the harsh discipline she received. And all of that together is enough to rise to the level a hostile work environment, because a hostile work environment can include comments that are not, just direct comments about her sex or about female officers. They can also include complaints about her performance, belittling her, ostracizing her, and otherwise, showing her that she is less worthy or not wanted at the prison. And there's the First Circuit's decision in Roy v. Correct Care Solutions really lays that out well. And then I guess just the final point is that, Autumn was experiencing harassment from prisoners and from a former prisoner, and the prison took absolutely no action to stop that harassment, and instead repeatedly assumed that she was the problem and disciplined her instead. That's further evidence, that alone really is enough for a hostile work environment, because she reported harassment and the prison really did nothing to stop it. So in sum, there's at least an even chance that Autumn was subject to the sex discrimination in a hostile work environment based on her sex. And I'm glad to answer any questions that you have.
Thank you. Commissioner Whitworth, questions for Ms. Layton?
Nope, I don't have any questions. Thank you.
Commissioner Ashby?
Yes, I do. Thank you. So it's my understanding that in a number of instances, male officers were disciplined with 40-hour unpaid suspensions for inappropriate contact with prisoners. Is that correct?
Yeah, so it's a little confusing because one is framed in terms of hours and one is framed in terms of weeks, but a 40-hour suspension is 1 week versus 2 weeks.
I'm looking at the investigator's report on page 6, very top paragraph B. There's a list, quite a list of those instances. And I understand the respondents' counsel to be saying that in those instances, those were cases where there was not prior discipline. Do you agree that that's the case? Is that what the record suggests?
If you could hold off on answer, hold on. The investigator had flagged before for me that the references to that in Ms. Morrell's presentation about 2 other male COs not having had prior discipline, that actually was not clearly stated in the record. Everything was de-identified. So I just wanted to clarify that.
Let me rephrase my question in light of that clarification then. Do you know of, in the record, do you know of instances in which officers were disciplined for 1 week's suspension when they had a similar disciplinary record to the complainant?
I don't think that's clear from the record, and it's also not fully clear from the record what they were disciplined for. Just going off of the information that was provided, I think the behavior sounds significantly worse than what Autumn did. There's no allegation here that Autumn was engaged in any kind of inappropriate relationship with the probationer that she received a 2-week suspension for contacting. She was contacting him, and I think the investigator found this, that she was contacting him to get him to stop harassing her, calling her at work, stalking her, following her home, driving by her house, and not because she had any kind of inappropriate or unprofessional relationship with him. Both of the descriptions that were provided for the people that got the 1-week suspension involved an actual inappropriate relationship or unprofessional relationship with a prisoner. And so she got double the discipline for behavior that was not as bad.
Yes, but isn't the issue of whether or not these other officers had prior discipline, isn't that really sort of central to both the complainant's case and the respondent's defense? The respondent seems to be arguing that that it's the prior discipline, which, as I understand it, the complainant did not grieve at the time, the prior discipline for having inappropriate contact with prisoners. It's the prior discipline which resulted in, first, an opportunity where there could have been a suspension, but there wasn't. She was simply moved to a different area of the jail, and then subsequently given a 2-week suspension instead of what other officers are receiving as a 1-week suspension. Isn't that sort of central to the case?
So, yeah, I'm not sure if it was clear from the record what the other, whether the other officers had discipline. In terms of the grievance issue, Autumn believed that she was working with the union to grieve all of these disciplines, and there were some issues in terms of what the union told her was happening and what was actually happening, that, you know, we don't need to get into here, but I don't think that the fact that she didn't grieve the discipline means that she agreed with the discipline. And obviously that's not the case here. And it also formed, you know, as it got to be more and more disciplined, she realized that there was a pattern of discrimination that maybe she hadn't noticed on the first one. But again, the behavior that she is alleged to have engaged in was not being inappropriate with a prisoner. There's no allegation of that. And the issue with the former prisoner has nothing to do with the other things that she was disciplined for. So I don't think it's necessarily true that she deserved harsher discipline, because the two things were completely unrelated. And that wasn't referenced in these investigations, that she, needed to be disciplined more harshly because of what had happened in the past.
Well, you agree the respondent has the right to engage in progressive discipline, correct?
Right. Yeah.
And are you alleging, have you alleged anywhere, I didn't see it in the investigator's report, are you alleging that they did not in fact apply their existing, if it's in the record, they didn't apply an existing policy to this complainant? Are you saying that they didn't follow the progressive discipline policy that they have at the respondent's business?
I don't think we're necessarily saying that they violated their progressive discipline policy. I think what we're saying is that the fact that she had so much discipline in the first place is evidence of discrimination, and that she wouldn't have had the first discipline for letting, for talking for too long with a prisoner, but for the discriminatory intent. So this may have been like a longer suspension. Arguably skipping from a 2-day suspension to a 2-week suspension is not following the progressive discipline policy, which is why there's people who got 40-day suspensions. But she wouldn't have even been in this position of needing to apply the progressive discipline policy if they hadn't discriminated against her in the first place by giving her harsh and, unnecessary discipline to begin with. And then it all just sort of compounded and built on each other and created a situation in which, they could argue that they were giving her progressive discipline.
If it is suspected that a person in the complainant's position was in fact engaging in inappropriate conversations with prisoners, you're not suggesting that it isn't appropriate that folks listen in on those conversations, are you? I know you're critical in your case in chief that the listening in somehow evidences some sort of discriminatory animus or unfair or disparate treatment. But it is appropriate, right? If they thought she was in fact doing that, it'd be appropriate for the agents of the respondent to listen in, wouldn't it?
It might be appropriate for a supervisor to do that, but this was like a gaggle of male officers who were not her supervisors just listening into her conversation. I think that if they thought something was inappropriate, they could have, reported it to a supervisor, which they did, but then they continued to listen into her conversation, which really at that point was not their responsibility or business. And I think it shows that they were, you know, that their animus in doing this was really they wanted to find something to get her in trouble. And even the captain who investigates these complaints noted at the Issues and Resolution Conference that was probably inappropriate behavior, that they quote unquote should have found something else to do after a little while, once the supervisor had been notified, and they shouldn't have kept listening to her conversation.
You make a pretty broad statement, I think, in your argument. I think it was in an oral argument just made a moment ago, that there was a wider and pervasive culture of this discrimination against female corrections officers. But then you cite three instances over a significant period of time indicating that culture. Is that your evidence for suggesting as much?
So those are the evidence. That's the evidence related to specifically what Autumn experienced. Aside from just generally male officers ostracizing her or, singling her out to report her for discipline and the discipline itself. We also submitted an affidavit from another female officer who experienced other incidences of sexual harassment and sex-based comments, including similar comments about, women being more trouble than they're worth, and, that women shouldn't be working at the prison. But those weren't comments that were made directly to Autumn. But yeah, there is evidence that this was happening to other female officers at the prison.
At least as to the hostile environment claim, how do you address the respondent's argument that there's no employer liability here, that in instances where, in fact, these instances of bad treatment, hostile treatment of employees occurred, that there was actual discipline? There was discipline of the employees, non-supervisory employees engaged in this kind of activity.
So there's a couple of things related to that. First, the discipline that they mentioned only occurred many months after it happened and after she reported it and after this suit was filed. So, do with that what you will. But also, there's a couple things that are cut and dry cases of employer liability. One is that Autumn reported she was being harassed by prisoners, and her sergeant actually pulled her out of the area where the prisoners were harassing her and where the harassment was really bad. And another officer nonetheless kept assigning her there, even though she was not supposed to be working in that environment. And so that's a direct example of employer liability for harassment, because they knew about the harassment and purposefully put her back in the environment that was harassing. And then actually use that.
Harassment by prisoners, though, correct?
What?
That's harassment by prisoners.
Sure, but an employer can be liable for third-party harassment if they know about the harassment and they don't take prompt corrective action. So this is, that's an example of, her experiencing harassment and the prison basically doing nothing about it and placing her back in that situation, which is, part of the same pattern as when she was being stalked by a prisoner and the prison did nothing to stop it. And then there's also the discipline itself is part of the hostile work environment, because it was sex-based and it affected the terms and conditions of her employment, and it was based on reports by the male officers who made these same comments. And so you can't look at just the comments in isolation or the discipline in isolation. There's a First Circuit case for O'Rourke v. City of Providence that says that courts should avoid disaggregating a hostile work environment claim into sexually oriented conduct or sex-based comments and instances of unequal treatment, and that the instances of unequal treatment are part of the entire hostile work environment. So those are the specific comments that I mentioned, but there's also this larger environment of the discipline that was disparate, the complaints about her behavior by other officers, and just a climate of ostracizing her and treating her differently.
Could I interrupt? Could I interrupt for just a minute? We have a lengthy agenda today, and if we could condense the discussion, keep it more abbreviated, I think everybody would really appreciate that.
Commissioner Ashby, any other questions?
Well, I didn't have any other questions in any event. I'm mindful certainly of our agenda, but I certainly have questions about this case I wanted answered. Thank you very much.
Commissioner David, questions for Ms. Layton?
It does seem to me significant as to what that standard is, whether it's severe and pervasive or severe or pervasive. And I'm going to ask Attorney Morrill, but you're clear that you think it's severe or pervasive, right?
Yes, I think Attorney Morrill will agree with me that it is severe or pervasive.
Right. And
as your lawyer, Ed, I can tell you it is severe or pervasive.
Thank you. Thank you. You were the next question, Barbara. And that listening to the conversations, nothing ever was reported as being inappropriate. And so your description of it is a gaggle of the guys snooping on her, right? And not coming up with anything
exactly.
that's, okay. That's good. Good. Thank you.
Thank you. Ms. Layton, you'll have 3 minutes left if you want to use them after we go back to Ms. Morrill. Ms. Morrill, you have 3.5 minutes left if you want to use them.
Yes, thank you. I just wanted to quickly clarify a few things that Ms. Layton said. The first thing I wanted to clarify was the de-identified list that we provided, the Excel spreadsheet of the disciplines. While it is de-identified, it still does identify the conduct that was engaged in and the disciplines that were issued, along with the gender of the correctional officers. And there are only 2 instances in which a male correctional officer was disciplined for similar behavior, and those are the 2 40-hour suspensions. So that would tell us that those officers did not have previous discipline for similar conduct within that period of time. Even though we don't know the names of the people. Second thing is with respect to the pod, the inmates going from pod to pod, although the first instance did involve one officer, a male officer, sending an inmate over to Ms. Dinsmore's pod, the third instance involved her calling and asking for that inmate to come to her pod. That was on May 8th, and that was after the sergeant had talked to her about it being inappropriate. With respect to listening in on the conversations, it was the control room officer who first, his job is to monitor the pods by video and to see if there's anything going on. He noticed that Ms. Dinsmore had been talking to the same inmate for an extended period of time. He told his sergeant about this, and the sergeant told him to listen to the conversation to make sure nothing inappropriate was being discussed. Now, she may have been talking about college, but talking to an inmate for a period of 80 minutes, no matter what they're talking about, is not appropriate. And it's the just over familiarity, talking to one inmate for that amount of time, it creates a danger. I do agree that the standard is severe or pervasive for a hostile work environment. Ms. Layton made the statement that Ms. Dinsmore felt that the climate was ostracized, that the people were ostracizing her. In fact, in one of the investigations, she was asked if she felt that the shift was ostracizing her, and she said no. She chose to keep to herself because she did not get along with the officers on night shift. And I think the other officers on night shift also agreed that there was a lot of bickering among them on that shift. And to answer your previous question, Commissioner Ashby, about when the protection order or when Ms. Dinsmore contacted law enforcement, the temporary protection order was granted on July 2nd, which was after the investigation started into her conduct. I think that's all I have, and I'm happy again to answer any questions or clarify.
Thank you. Commissioner Whitworth, any follow-up for Ms. Morrell?
Nope, thank you.
Commissioner Ashby?
No, thank you.
Yep. Commissioner David?
No.
Okay, back to Ms. Layton. You have 3 minutes.
Thank you. Just a couple quick things. So one, Kelly brought up the bickering on the night shift and that Autumn chose to quote unquote keep to herself. The bickering was about their comments about female correctional officers, and it was part of the hostile work environment. They, made claims that a female officer had slept with an inmate and other things that Autumn found offensive. And so, Autumn decided to remove herself from that environment. Those comments about female officers and stereotyping female officers were ostracizing. And that is why, she felt she needed to remove herself from that environment. And then in terms of the discipline that the other officers received, the way it was described, and again, the information was limited, but one was engaging in an unprofessional relationship with a prisoner beyond the course of fulfilling his normal duties. Here, there's no allegation that Autumn was engaging in any sort of unprofessional relationship with any prisoner or with the former prisoner that she received the 2-week suspension for contacting. So, that behavior is arguably much worse, but she received double the discipline for it. The other discipline that a male CO received a 40-hour unpaid suspension for was giving, accepting, or soliciting gifts from a prisoner, which is, an egregious breach of a correctional officer's duty and, leads to questions about bribery and other things like that is much, much worse than simply trying to stop somebody from stalking you. So, I would submit that just based on the information in the record, those instances of conduct were much worse and received less discipline. And again, there's no evidence about whether they had received discipline in the past and whether progressive discipline was warranted in those cases. So it's hard to compare in that respect. And yeah, I think that's all I've got, but I'm glad to answer questions.
Follow up for Ms. Layton, Commissioner Whitworth.
No questions.
Commissioner Ashby?
No questions, thank you.
Commissioner David? No, thank you. So then we would go to the Investigator Thompson Crossman.
Okay, can you hear me?
Yes.
Great. So good morning, my name is Kit Thompson Crossman. I'm the investigator assigned to this case. Just clarify a few things and then I'm happy to answer your questions. In terms of the disparate treatment, I would echo a point that Attorney Layton made, which was that from the record, it appears that complainant was initially disciplined for things that other correctional officers had done and had not been disciplined for. And I would reiterate that at the conference in this case, the captain said that if the male correctional officer had in fact sent the prisoner to complainant's pod, he should have been disciplined for that, and he wasn't. So it's not that she received discipline that she shouldn't have had, it's that she received discipline in case for behavior that in some instances male correctional officers were not investigated for at all or were not disciplined for. With regard to the comparator information, I have as much comparator information as I was able to get. And so with regard to the 2 male officers who received 40-hour unpaid suspensions, it's true that those are the only 2 in the record, but it's also true that there are several investigations from about 1.5 years prior to that include male COs who were disciplined for things similar to what complainant had done. And there's no way for me to know whether those male COs are the ones who engaged in the conduct that resulted in a 40-hour unpaid suspension or not. So I don't have any information as to the disciplinary records of any of the CEOs other than complainant. So I made my recommendation based on the information that's in the record that was available to me. With regard to hostile work environment and employer liability, I will say that complainant reported the comments she was hearing about female correctioner. Sorry, my kid is about to go get a flu shot. They're 7 months old. They're not excited about it, and I don't blame them. So with regard to the hostile work environment, she reported the comments that she was hearing about female correctional officers to Captain during the course of his investigations, and he undoubtedly is in a supervisory position. So there was employer liability sort of from the get-go. And it's true that the following investigations that did occur with regard to the male CEOs who engaged in some of the behavior in the record happened some distance after that was established. It's also in the record that some male CEOs reported to Captain hearing other male CEOs make comments about female correctional officers and why they should or shouldn't be working in the jail and what they might or might not have been there for. Okay. So with regard to the listening in, I think that situation has gotten a little muddied. So there was one correctional officer in the control room who was sort of monitoring what was happening. He saw a complainant speaking to this prisoner for what he determined was an extensive period of time. He reported that he was ordered to listen to that conversation. 2 or 3 other male CEOs then came into the control room, either saw or were told that complainant was talking to the CEO, and then they just like hung out and listened for a pretty long time. And at the conference, Captain said, yeah, they should have found something else to do. The one guy who was ordered to listen to it, fine, he was ordered to listen to it and make any report, but these other guys, they were there for enough time that they should have found something else to do. Yes, okay, I'm just trying to read my handwriting, and I believe that complainant had already reached out to law enforcement by the time she reported to her supervisors that this probationer was harassing her. She had not had the protection from harassment order hearing at that point, although she had filed it. So with that, I'm happy to answer any of your questions.
Thank you. Commissioner Whitworth, questions for the investigator?
No, Kit, I just want to say that this was probably a really challenging because so many moving pieces, and your investigator's report was very easy for me to follow. So
oh,
thank
good.
you.
I'm glad to hear it.
Even
Thanks.
given that you couldn't probably get all the information that you wanted. So
and that's not, I'm not trying to slam DOC in this. There's a lot of confidential information, and we have to do consent orders and court orders and stuff like that. So it's not, I'm not trying to say anything bad about Attorney Morrell's participation in this, just that I got the information that was available.
Right. No, I get that. Thank you.
Commissioner Ashby, questions for the investigator?
None, thank you.
Commissioner David?
No.
Okay.
Thanks.
So, I'm sorry?
I just said thanks.
Okay. So we've heard from the parties and the investigator. So at this point, we would be looking for a motion or motions. There are 2 proposed findings here.
I'd like to take them separately if we might.
Sure.
I'll move to find the second recommendation first, that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of sexual orientation and or disability, and that therefore that claim should be dismissed in accordance with the Act.
Second.
Is there any discussion? Nope,
Oh,
no vote
sorry.
yet. Any discussion on that one? Seeing none. Now, Deb, go for voting.
All in favor, raise your hand and say aye.
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 So the vote is 3-0.
And is there a second motion?
I will move that we reject the findings of the investigator and find that there are no reasonable grounds to believe that the Department of Correction, that the respondent discriminated against the complainant on the basis of sex, either by disparate treatment or hostile work environment, and that the claim be dismissed.
Is there a second? Without a second, the motion fails. Is there any other motion?
Yeah, I'm trying to skip. Yes. I'll move that we found that there is reasonable grounds to believe that the respondent discriminated on the basis of sex by disparate treatment and hostile work environment, and conciliation should be attempted.
Second.
So as motion for reasonable grounds, it's been seconded. Is there any discussion?
The basis for my motion, which failed for want of a second, in my opinion, is that I think this case does suffer from a lack of comparators, but from what I do see and what has been developed by the really excellent report, by the way, of our investigator, is that we should afford the respondent latitude and discretion to discipline in the way that it does. This is a complainant who had 2 prior instances of inappropriate contact with prisoners, and then without complaining to her commanding officer, reached out directly to personally to the home of the former prisoner. I just think had that been a male guard calling a female former prisoner, it wouldn't be a close call. The 2-week suspension with prior discipline doesn't shock my conscience at all, doesn't point to me that it has been disparate treatment when compared to the prior disciplines of other fellow employees. I did read at the top of page 6, paragraph B, the list of, or the litany of comparators. And I see, for example, in one case, a male CO was issued a 40-hour unpaid suspension for, quote, engaging in unprofessional relationship with a prisoner beyond the course of fulfilling his normal duties. And that's all we have, and nothing more, nothing mentioned about a sexual relationship, for example. And then another person got a 40-hour unpaid suspension for apparently accepting gifts, which is more analogous to this case than would be, say, an inappropriate sexual relationship. I think that we'd be tying the hands of the respondent if we intervened in their choice, their choice to discipline, by the way, which was not either grieved. The first 2 instances were not grieved, and the complainant's attorney indicates that did not appear to be in violation of the policies they have in place to discipline. So I just don't see. And as far as the hostile environment, I'm convinced, I believe the respondent's argument that the employer liability is not met here, proven employer liability is not met here. And furthermore, I'm a little bit critical of the claim that this is severe or pervasive. It's 3, as I understand it, 3 instances of boorish behavior for which I understand the folks that made the comments, at least in a couple of those instances, were disciplined. So that's the basis for my unsuccessful motion and the reason why I'll vote against Commissioner David's motion.
I don't disagree that it's a close call. I actually do focus on the work environment on page 7, paragraph 13 is what is most impressive to me, and focusing on the fact that I think it's showing the investigator's judgment that it's a pervasive environment. From the beginning, she's the subject of comments. I think it does reach the employer liability to be training and constantly dealing with that part of our culture that one can see shows up in that male-dominated environment. So I think it was pervasive, and that's why I'm voting for it.
Any other discussion? The motion is to find reasonable grounds to believe unlawful discrimination occurred with regard to sex, disparate treatment, and hostile work environment. All those in favor of the motion, raise your hand and say aye.
Aye.
See 2 in favor. All those opposed, raise your hand. Okay, the vote is 2-1. The finding of reasonable grounds is upheld. So there's one of each for one reasonable grounds, one no reasonable grounds. The commission will be in touch with the parties by letter. At this point, I think we should go back to the first case, which was H20-0372. We have the investigator, we have the lawyer for respondent, we have complainant here. So commissioners, this was Theberge versus Lewiston Housing Authority et al. You all, Jeff, Commissioner Ashby made the motion to find no reasonable grounds. Commissioner David seconded. You all voted in favor of it. At this point, if you do want to let the complainant present on her case, you would need a motion to reconsider your prior vote.
I'll move to reconsider my prior vote.
Second.
All those in favor of reconsidering? 1, 2, 3. Okay. So let me turn to Ms. Theberge. I have to find where you went. There's lots of call-in callers here, so I don't remember which one you are. Can you unmute? Oh, okay. All right. So
yes.
Ms. Theberge, you have an opportunity. You have 10 minutes to make a presentation about what you disagree with in the investigator's reports. Are you ready?
Well, I would like to, if you could time me for 5 minutes so I could have 5 minutes left over in case I need to use it to, you know,
yes.
What's the
I
word?
will tell you when it's 5 minutes. Okay?
Okay.
Okay, go.
Well, I'm rather upset because I find it highly disturbing that the management, Chris Kilmurray, Carla Harris, and Travis are lying and manipulating and things to their advantage, and they're weaponizing the constitutional rights to their advantage and weaponizing the policies of housing authority to their advantage to target me and discriminate me the way they're doing, as I've mentioned. And I would have turned in a lot of evidence that would have supported my case, but the reason why I wasn't able to is because I have a few doctor's notes to validate. I've been sick as a dog, and I've been in and out of the hospital 2 or 3 times the past month from November through December. So I've just had it's just bad timing, but I just find it highly disturbing how they're lying and falsifying evidence. They're abusing their position of power. They're lying like Travis, for example, he's lying saying that he didn't tell the security guy not to give me legal advice when he did. I had a phone appointment one morning with the security guy, and he even said, yeah, Travis told me not to give you legal advice. And then they all lied and said they didn't. And I'm upset because they're lying. They're saying that they know my learning disability better than I do, putting words in my mouth and twisting words around. And I never understood the denial letter for the bug inspection. I still don't understand it. They're contradicting themselves. They say they refuse to talk, argue, or debate the denial letter and refuse to talk about it. But yet they turn around and say, oh, we'll tell us what you don't understand. We'll give you the answers to your questions about the denial letter. So they're contradicting themselves. They're playing games. They'll say one thing and then say another. And I'm just so tired of their games and their disrespect and their discrimination towards me. And it's just disgusting behavior. And nobody has a right to treat someone that way. And they're treating anybody who's disabled or not disabled in the building where I live is being treated, getting the accommodations they need, being treated fairly for their disabilities or health conditions, but I am not. And I don't feel safe where I live. They're endangering my health, safety, and well-being. And I'm just tired of it. And it's about the principle of the matter of standing up for what's right and defending myself as a disabled person. And they're discriminating discriminating me on my health conditions and disabilities, and I'm just fed up. This has been going on for quite some time, and I need something done about it. And they're lying about the other stuff they had said, like I had mentioned before. Carla had lied about, they had lied saying that I'm sorry, I'm tired. Carla had lied saying that she had always, for crying out, sorry, I'm just trying to think of I'm just having a bad day trying to put things in the right words because of my disability. I'm sorry. What they've been lying about is, I don't know why the security guy is lying, but he's lying saying that he had lied in his testimony saying that I had basically that Travis never told him to not give me legal advice. He lied about other stuff where he lied saying that in the information, I'm trying to think, he was giving false information, the security guy, about saying, for crying out loud, he was giving false information about me pertaining to saying that, I'm sorry, I'm just really stressed out and having a bad day trying to put things into words. The security guy lied pertaining to giving other false information about me on not just what Travis said, but also saying that I had never. I'm sorry.
Mr.
Can I
Burge, just
pause?
so you know, that's about 5 minutes.
That's already 5 minutes. Yeah. Can I take a pause for a minute? So I can just can I pause it for a minute so I can think? I'm just having a bad day trying to put things into words, and I just need a second.
I can
Can
give you
do that?
about 30 seconds, but this is generally not something that we do, is let people pause their time. So just take a minute, take a few seconds and think.
Yeah, I'm sorry. I'm just stressed out and having a bad day trying to put things into the right words because of my learning disability.
Okay, you ready to get started again?
Yeah.
Okay, you have 5 minutes left.
Well, I was also upset because the security guy was lying about other information, not just about the situation with Travis, but lying about in the testimony, saying that sorry, I'm just really stressed out. He was lying, giving false information about me, saying that oh, for crying out loud. I'm sorry, I'm just having a very bad day. It's just pertaining to my disabilities with the situation. I'm just upset because I've just getting tired of the management of the housing authority just closing the lines of communication. They're telling their employees not to accommodate me. I've verified this with one of their staff members, another property manager by the Hillview buildings. I think that's the location. It's just they keep making sure that the more I try to fight to be accommodated that I desperately need for something, they're intentionally making my life miserable and endangering my health, safety, and well-being. And their dispute in and also what's upsetting me is the reason why there would have their security guy lie about information on stuff is the only thing I could think of is either they're threatening his job or threatening to fire him or something to get him to lie, because the security guy would never, is a nice guy, and he's not the type of person, being a good judge of character, to my understanding, lie and throw somebody under the bus to get ahead in life. And I just think it's wrong with them manipulating the laws to their advantage and abusing their position of power, doing what they're doing to me. And they're arguing that they're contradicting themselves, saying that they need doctors to validate my health conditions, but yet I've had eyewitness testimony of friends and family members see me break out firsthand pertaining to my sun allergy condition, and written testimony signing and dating this. It's no different in the court of law. If someone has seen firsthand your reaction due to a health condition, that they could testify on your behalf, validating that. And my friends and family members weren't lying, validated in notes of seeing me firsthand breaking out. And the housing authority accepted this and accepted my doctor's notes through RRAs over the 3 years of me living here, contradicting themselves, saying in 1 minute, oh, you need a doctor's note, this isn't good enough, but yet accepting my PCP, verifying my sun allergy condition through an RRA so I could keep the windows closed year round due to sun allergy condition, and they approved it without a specialist verifying the sun allergy condition, but they accepted the PCP validating this in the past. Now they're contradicting themselves now at this point in time, saying it's not good enough, that they want doctor specialist that specializes in this particular health condition to validate this condition because I'm allergic to their pesticide chemicals. That's what I mean by contradicting themselves. 1 minute something's accepted or something seems okay, and the next minute they turn around and play games and contradict themselves. This is what I've been dealing with the 3 years I've lived here, and it's a nightmare. And and with them getting the security guy to lie about other stuff, and I'm just so stressed out, I'm forgetting the other important information I'm trying to mention about the security guy, what he lied about, other information he's lied about besides what Travis said. They got the security guy to lie about it was something important. I'm sorry, I'm trying to hurry. Can I get a...
Actually, that's the end of your time. That's 10 minutes.
Yeah.
Yeah. So at this point, at this point, I'm going to ask the commissioners if they have any questions for you. They might or they might not. So I'm just going to ask you to hold on there, okay?
Yeah.
So, Commissioner Whitworth, any questions for Ms. DeBurge?
No questions, thank you.
Commissioner Ashby, questions for Ms. DeBurge?
None, thank you.
Commissioner David?
No.
All right, so Ms. DeBurge, you've used your time. I'm going to mute you, and then we're going to hear from the attorney for the respondents. Mr. Lamourie, thank you for being back with us. You also have 10 minutes to present.
Thank you. I don't
feel free to not use them all.
Yeah. Thank you very much. Good morning. The Lewiston Housing Authority's mission is to provide decent, safe, affordable housing free of discrimination to eligible people in need of housing assistance. And a significant number of the residents at Lake Street Towers, where the complaint resides, are disabled, elderly, or both. And over the years, a large number of those residents at Lake Street Towers have requested and been approved for accommodations related to their disabilities. These have encompassed a variety of disabilities, including, mobility impairments, mental impairments, and other medical conditions that, render it difficult for residents to enjoy the rights of other non-disabled tenants without some form of reasonable accommodation. I think the commissioners are all well aware of the fact that the process associated with evaluating reasonable accommodations, both in the employment and here in the housing context, that process is a two-way conversation. Jurisprudence under the Fair Housing Act, under Title II of the ADA, and under the Maine Human Rights Act, all make it clear that the parties to this process are expected to engage in a interactive dialogue. It's a flexible back and forth process. Okay. Now, I want to emphasize this because I want the commissioners to understand that the authority, has well-established procedures, which are a condition of their HUD licensing, for identifying and processing resident requests for accommodation. And as part of this procedure, the Housing Authority has trained its staff person in how to work with residents like the complainant in completing the paperwork necessary with a request for accommodation, getting those requests processed, and and making a grievance procedure available if there's a disagreement. This is done in a way that's consistent with that interactive process. We think Investigator Neal was very effective in pinpointing the relevant facts asserted by both parties in this case, ignoring statements that had no real bearing on the determination she was required to make, and in drafting a well-reasoned investigator's report. And she did that all within an expedited time frame. During that time frame, the parties engaged in a issues and resolutions conference that was about a half a day. And Investigator Neal coordinated telephonic fact-finding investigations of 3 of the individually named respondents, who are all senior managers at the Housing Authority, as well as an interview of a key fact witness. This is the security officer that the complainant has referenced in her comments. And I also understand that the complainant was interviewed by Investigator Neal over the course of several telephone calls, both during the fact-finding process and just prior to the close of evidence. So let me just finish, at least as part of our statement, by saying that there's never been any standing rule that the authority intended to restrict who the complainant can interact with in terms of staff people. And there's never been any unwritten practice in which staff have been instructed to ignore her. And that encompasses her requests for reasonable accommodation. Finally, I guess I'd like to reiterate once again what I conveyed in writing as part of our submissions and during the parties' issues and resolutions conference, which is that the authority is prepared to continue to offer the complainant reasonable, meaningful opportunities to interact with its staff persons on matters that concern her, including her request for accommodation. So at this point, I don't think I have anything further to add. On behalf of the respondents, thank you for the opportunity to present this information, and I'd be happy to respond to specific questions that any of the commissioners have.
Thank you. Commissioner Whitworth, questions for Mr. Lamoury?
No questions, thank you.
Commissioner Ashby?
I have no questions, thank you.
No.
David? Okay. We've heard from the parties, now to Investigator Neal.
Good morning, Commissioners. My name is Alice Neal. I was the investigator on this case. I think the parties have already laid out what their presentations are and their arguments. I just wanted to clarify a couple of things, and then I'm happy to answer any questions that you have. When complainant was talking about her ability to give evidence in this case and multiple hospitalizations or things that impacted her ability to put evidence in the record, that is an information that was actually in the record in this case. And so I just wanted to clarify that for you. Other than that, you know, my report and my recommendations still are the same based on the presentations that I'd heard from the parties today, but I'm happy to answer any questions.
Questions for the investigator, Commissioner Whitworth?
No questions, thanks.
Commissioner Ashby?
No, thank you.
Commissioner David?
No.
Thank you, Alice. So there are two proposed findings that can be taken separately or together.
I propose to take them together, and I move that we find there's no reasonable grounds to believe that respondent discriminated on the basis of disability or that there was retaliation, and that the complaint should be dismissed in accordance with the statute.
Second.
So there's been a motion to find no reasonable grounds on both counts, and it's been seconded. Is there any discussion from commissioners? Seeing none.
I do want to just make one quick comment. I just want to, this probably isn't the place for this, but I liked having the summary of the investigation, the timeline that Alice provided was really helpful. So thank you.
Okay, so all those commissioners in favor of a finding of no reasonable grounds to believe disability discrimination occurred related to reasonable accommodations, and no reasonable grounds to believe that retaliation for asserting Maine Human Rights Act rights. All those commissioners in favor, please raise your hand and say yes.
Aye.
Yeah. 1, 2, 3 commissioners voted in favor. So both findings are no reasonable grounds, and the commission will send the parties a letter. Ms. DeBurge, we will send you a dictated version. And that's the end of this case, Ms. DeBurge. We have 8 other cases we have to get to, and we're going to be losing a quorum at 2 p.m. So I'm afraid we have to move on very quickly. So we will send you a letter.
Well, I don't understand how the vote took place earlier this morning before I even got on the phone. That's what I don't understand.
And I will be glad to talk with you about that, but not at this moment when we have to get to 8 other cases. So I will be glad to talk with you, but not right now.
Yeah.
Thank you. So the next case is, yeah, Deb, you want to call the next case?
Sure. The next case is E190172, John Sorensen v. Shaw Supermarkets. It is a reasonable grounds case. Is anybody here for the respondent?
Good morning. Elton Harmon here for Shaw Supermarkets, Inc.
And before we begin, I meant to say this to all the folks on the call, which is that I did just learn that we'll be losing a quorum at 2 p.m. So we really, really need to move all the cases along as quickly as possible. I don't want to prejudice anyone's right to present their case or the commissioner's ability to consider them, but I also really do not want folks later in the agenda to have to come back next month instead of having their cases heard today. So please try to keep things, everyone, as brief as possible. Mr. Harmon.
Good morning to the commissioners, Director Sneerson, Investigator Brindley, and Ms. Aiello, who is counsel for the complainant. I represent Shaw's Inc., and I'd like to talk a little bit about this case, which actually is also a scheduling case similar to the first one we started with. It is our contention that the investigator, Ms. Brindley, properly found that there was no hostile work environment. However, we do disagree and object with the determination that we failed to accommodate Mr. Sorensen. Just quickly through the background, because I know we have to move quickly. We hired Mr. Sorensen. Mr. Sorensen was the son of a long-term employee of ours. We, almost had a no good deed goes unpunished situation because we wanted to make sure that transportation-wise, he would be able to go to work or be picked up from work by his mother. So we attempted to do that. We did not require medical documentation. We hired him with that understanding. And because there is a difference between the number of hours that she worked as a part-time employee, which were as many as 30, some of our part-time employees are almost at the full-time employee number. But she was able to work that, and he, because he was a bagger, had fewer hours that were available. And of course, the law doesn't require us to make a new job for him and make additional hours. So what we did was, as much as possible, made sure that the schedules aligned. But again, because more hours were needed for her versus him, there would sometimes be some extra hours on the beginning or the end, or extra time where the schedules didn't align perfectly. That was a discussion that was had with the mother, and we were told that he was okay with being able to come in as long as she's able to pick him up. Now, there is some case law out there and a little bit of a split, but it indicates that we don't have to be responsible as an employer for individuals getting to and from work. So before, but we did it anyway. It ended up being a temporary kind of accommodation because it actually didn't work as well as we thought it would work. But we did our best. And I apologize to Investigator Brindley because I think I went into far too much depth explaining how difficult it was for us to do this process of rescheduling. That difficulty does not mean, however, that we didn't believe it was important for us to do that. So I apologize for that because I could have been loquacious in that particular part. But anyway, it comes down to failure to accommodate, which requires that the complainant be qualified, that we knew about the disability and the need for an accommodation, and then we failed to accommodate such that the complainant was unable to do the job. Any of those, if they're missing, means that there is no reasonable cause. And it's our opinion that the last prong is missing. At the end of the day, the complainant got upset during a meeting, which we considered to be part of our ongoing requirement to engage in an interactive process. We called him into an office when he was upset one day about the schedule. We called his mother there as well. And during the meeting, he stood up and said and walked out, "I quit." So that is not something that we went into that meeting thinking would happen. We asked if he wanted to be, if he was sure, asked him to come back in. His mother did the same, but he was sure he'd made his decision. But that does not equal constructive discharge. And the third prong cannot be established without that constructive discharge. So again, it just doesn't make sense that we would hire him knowing of his disability and even try to give him the accommodation of a perfect schedule just to terminate him. And I want to be very clear about this. 8 shifts later, it was only 8 shifts. It was barely 3 weeks. So this is not this process that we got so tired of so quickly. It was a process that needed to be reevaluated. And that's what I'll stop at because that's the main crux. Even without one of those elements being satisfied, in this case, the constructive discharge, then the case, we should not have that finding against us. And again, case law exists out there indicating that we do not have to be responsible for getting someone to work. They're getting to work options or leaving work. You know, we tried, but in the end of the day, we can't be held liable for that. I'll reserve the rest of my time.
Thank you. Questions for Mr. Harmon, Commissioner Whitworth?
Sorry, no questions.
Commissioner Ashby?
Yes, just one or a couple. The finding in the investigator's report based on an affidavit provided by, or a sworn statement provided by the mother, that that respondent's supervisor told complainant in this meeting that you're talking about that the situation was not working out and that he was being discharged. Do you dispute that?
Yes, sir. Commissioner, we absolutely dispute that. We did not go into that particular meeting hoping to terminate him. And in fact, in order for him to be terminated, I would have to, as Director of Associate Relations or my predecessor, would actually have to approve a termination. And there was no such termination authorized or given to all of us. And that is
that statement you just made, is that actually in the record? I guess the investigator.
The investigator is shaking her head as if it is not.
The question about whether there was an authorized termination or whether I have to make the decision.
Whether the process of terminating an employee would have to go through you. I've learned apparently that it was not in the record. So, I mean, you understand that we're faced with the investigator's report. That's the fact finder in this case. And we have that fact, which is challenging for us. Do you agree that if that fact were true, you would have not only a constructive termination, but an actual termination, right?
Well, right. It would be an active termination, but they don't go together. That if we actually went in there to say you're terminated, why would we be relying specifically on a constructive termination? There's actually a debate about whether that happened. We don't believe that it happened, and I won't go into, as you said, our process for that. So,
okay. Thank you.
Again, that meeting, just quickly, sir, was about continuing.
Actually, he indicated that you answered his question, Mr. Harmon. I am sorry, I don't want to cut you off, but we're running out of time for 8 other cases.
You are. Understood.
Yeah. So,
that's fine.
Yeah. Commissioner Ashby, did you have any additional questions? Okay.
Thank you, sir.
Commissioner David?
No.
Okay, thank you. Sorry again, Mr. Harmon. You have about 4.5 minutes left and we'll be back to you. Is there someone here for Mr. Sorensen?
Kristen Aiello for Mr. Sorensen.
Yes.
Thank you for this opportunity. Good morning. Investigator Brindley reviewed all the information submitted by the parties in this investigation. She requested specific follow-up, including sworn statements, and she concluded that there are reasonable grounds to believe discrimination occurred. She is correct in her assessment. Her assessment of reasonable accommodation is on page 4 is straightforward. This case is straightforward. There's no dispute that John is a qualified individual who is able to do the essential functions. He was hired as an experienced bagger. He has mental disabilities which substantially limit his verbal communication and interaction and have required special education and vocational rehabilitation services. Prior to beginning work, John and his mother, who already worked there, requested a modified schedule to be able to work the essential functions of the job, namely to have the same schedule or very close to the same as his mother's for purposes of assistance with transportation and communication if necessary. Respondent provided that modified schedule. It worked. After providing this accommodation, respondent unilaterally and without notice stopped providing the modified schedule to my client. So on a day that is really important in terms of the analysis of this case and what happened and the reason for the July 30th meeting, on one of these days when my client was not accommodated, he went to work with his mother and he sat outside on a bench outside of Shaw's for 3 hours before his shift started. Now, mind you, they had not told him that we're not going to accommodate you anymore. They just started him 3 hours later. So he sucked it up and sat outside and waited to start his shift. Now, at that point, his supervisor came by and was not happy to see him sitting there. She demanded to know why he was sitting there. John can't verbally answer. It's very difficult for him to verbally communicate due to his disability in communication. Supervisor actually demanded that he speak. She repeatedly asked him to speak. He became very overwhelmed and upset. Supervisor chided him for sitting there and repeatedly asked him to speak. He responded. He was upset. He got to the point where he blurted out, "You're supposed to give me the same schedule as my mother." Supervisor told him that he can't be accommodated. All of this is in sworn statements in the record. So what happened soon after that? On July 30th, lo and behold, management called a meeting. So respondent is now recasting this meeting as a reasonable accommodation meeting. But there are several reasons why it's clear that it was not a reasonable accommodation meeting. There was no evidence that they called this meeting in order to work with him to work out a schedule and try to find some common ground and meet their obligations under the law. Rather, as the record clearly establishes, at the outset of the meeting, management said, "This isn't going to work and you need to be able to speak with us." Manager followed by a description of a recent occurrence when the manager said hello to Mr. Sorensen and he did not respond. This to them was problematic. And clearly there was a focus on their problem with his verbal communication, although verbal communication, there's no dispute that it's not required as part of the essential functions of job of bagger. So at the end of the meeting, again, my client became very upset. He really has a difficult time communicating. He was so upset that he blurted out, "If you're going to fire me, I quit." So if we are to believe that they weren't planning on terminating him, it would stand to reason they would say, wait, we're not going to fire you. Let's go back to the possibility of reasonably accommodating you. That didn't happen. We have sworn statements supporting that. I'd also like to address respondents' argument that there was no constructive discharge. They say there was no evidence of the alleged failure to accommodate was so unbearable that complainant would be compelled to resign. Well, let's just think for a minute to grasp the effect of being told that he must speak, what that had on Mr. Sorensen. Let's consider an analogous situation where an employer hires a qualified individual who uses a wheelchair. When that individual shows up to work, the employer demands that they walk, despite walking not being an essential function of the job. The employer nonetheless demands that the employee walk. Same is true here. Because of my client's mental disabilities, he's severely limited in his ability to communicate verbally. And telling him he must talk is akin to telling someone who uses a wheelchair that they must walk. I think the reasonable grounds finding that there was constructive discharge clearly is appropriate here, where any reasonable person facing such conditions, such working conditions, would feel compelled to resign, as Mr. Sorensen does. He was faced with a situation of being told, there's a problem with you not talking. Respondent has argued that a finding of constructive discharge is not consistent with no finding of hostile work environment. But as you know, there's different standards for each assessment of every case. Constructive discharge or hostile work environment is conduct that had the purpose or effect of unreasonably interfering with Mr. Sorensen's work performance or creating intimidating, hostile, or offensive working environment. Now, certainly it's arguable that being demanded to speak over and over again could create a hostile work environment. That is, as it may be, the investigator did not make a finding on that, but she did make a finding that that there was constructive discharge. And I think given the situation, the test for constructive discharge is whether a reasonable person facing such unpleasant conditions would feel compelled to resign. So I think in this case, it's clear there's little dispute actually that the reasonable accommodation, failure to reasonably accommodate claim standing by itself, there was a failure to reasonably accommodate when they stopped accommodating my client and gave him a different schedule, which led to him sitting outside Shaw's. Had they discovered that, oh, this is problematic, we want to talk about other accommodations, had they done that early on, it would have been a different situation potentially. where the parties would have talked, they would have discussed the situation and tried to find common ground. I also want to suggest that, or point out that in respondent's own submission of description of the job of bagger, it says baggers can work up to 36 hours. So I'm not sure where the difference is. Just because there are different hours that parties are working doesn't mean that they couldn't find reasonable accommodation. And I would also suggest that it's surprising to see respondent arguing that in the written submission that there was no, they didn't have difficulty. In fact, it was an impossibility because of the differences of schedules. And there is no support for that in the record. There's the issue before this commission on the reasonable accommodation claim is whether or not it would be an undue burden for them to provide that accommodation. Now, according to them in their written submissions back in July, they explain all the reasons why it was difficult to provide it, because they have an automated scheduling system and they had to print out the system, or they had to come up with the system and then change it, or the schedule and then change it. And it was laborious prior to having this automated schedule system. So that may be true. It may have been more cumbersome to provide this accommodation to my client, but it was, it's required. It's required under the ADA and the Maine Human Rights Act. There's little dispute here on many of the facts in terms of my client being able to do the job with or without reasonable accommodation, and therefore he should be receiving the reasonable accommodation that they unilaterally denied. So I'm happy to reserve, I don't know if I have any time to reserve, but I'll do that. I'm happy to answer any questions at this juncture.
Thank you.
Thank you.
Questions for Ms. Aiello? Commissioner Whitworth,
No questions.
Commissioner Ashby,
None, thank you.
Commissioner David.
Is it correct that this all blows up after 8 shifts, as Attorney Harmon said?
You know, I'm not sure of the number of shifts. It sounds like that could be accurate. I think he was hired, he started working, I mean, there wasn't a lot of time, maybe a month in between. So it's possible that he was working for a week or so, and then they just unilaterally stopped scheduling him, if that's what you mean.
And the footnote 2 at the beginning of the report says that there's no further consideration of an abusive work environment. And this stuff about asking him to speak, and your analogy about demanding that a person that can't walk seems to be directed to a hostile work environment, isn't it?
Sure. I think that we claimed hostile work environment as part of this case. We disagree that there was no hostile work environment, but given that the commissioner made findings in my client's favor, we were prepared to go forward with those. But I think if the commission were to find hostile work environment, we claimed it. It's part of our claim.
That's all.
Thank you.
Thank you. You have about 1.25 minutes left. And
Thank
again,
you.
I'm going to encourage the parties and counsel to keep it brief. Mr. Harmon, you have about 4.5 minutes left, should you want to use them all.
I understand the need to rush, but I actually do need to use them. I apologize.
Do not apologize. That is your right.
I appreciate that, Director. Just very quickly, I do need to go through the facts. The mother who has been working for us for quite a while and continued to work with us after we supposedly treated her son with such disdain as we terminated her. She was a part of all of these processes so that we did not have to speak to him directly at all times. She was the one that was happy that we said we can do the schedule as close as possible. So we did the schedule as close as possible. It wasn't unilateral. We brought him in to meet on the 30th because he was upset the previous shift. If you are upset about your schedule, any manager would bring you into a meeting to say, what's going on? So with respect to communicating with him directly and forcing him to communicate directly, that just simply wasn't the case until his mother gave us permission to do that. So very quickly, we usually communicated through his mother. And at some point she told us, you don't have to tell us he needs to go. I don't have to go tell him he needs to go to the break, to take break for water. She said, you don't need to talk to me about these little things. And she's changing her story now after the fact, which is a little concerning. But the fact that she continued to work kind of, goes to the fact that she wasn't necessarily upset with us about that. The fact that he was sitting there for 2 hours, that was one shift that they just didn't have the same number of hours. And that's just a function of cashiers being needed more than baggers. And we don't need baggers every day, and we don't need people that would kind of corral the carts, which is his other part of his job. So we would have welcomed him back, but he quit. At the end of the day, he quit. And we do not believe that the rest of the standard for constructive discharge, which is no reasonable person would have continued to stay working there, it just applies. He quit because he was frustrated. So that's all I have to say at this point, unless there are questions.
Yep. Follow-up questions for Mr. Harmon, Commissioner Whitworth?
No, I don't have any, thanks.
Commissioner Ashby?
No, thank you, Mr. Harmon.
Thank you.
Commissioner David?
No.
Okay, thank you, Mr. Harmon. Back to Ms. Aiello. You have about 1.25 minutes left if you want to use them.
Just to clarify a couple of things, there was an agreement from my client and his mother that it could be scheduled within an hour approximately, because they really did try to work with Shaw's, but it was 3 hours that he was being made to sit on a bench and then got chided for it. It's true that Shaw's usually communicated through his mother, which was a reasonable accommodation. It's also true that his mother said, you don't have to come to me and ask me if he wants a drink of water. He can nod, he can shake his head, he can take direction. There was no question about that. Even if their cashiers need more hours than baggers, that does not meet the standard of undue burden. The standard of undue burden is what applies here, and Shaw's didn't provide evidence that they had met it. And I would just encourage the commissioners to uphold the findings recommended by Investigator Alex Brindley. Thank you.
Follow-up questions for Ms. Aiello, Commissioner Whitworth?
No questions.
Commissioner Ashby?
Just one, does the respondent have an obligation under the act to accommodate the transportation issue raised by the complainant in this case? Attorney Harmon indicated that the authorities are sort of split on that issue.
Well, I would look to U.S. Airways versus Barnett, which talks about the issue when it comes to reasonable accommodation is whether or not the individual is asking for a method of accommodation that is within the run of cases, that is in the usual run of cases. The issue here is whether or not the modification of the schedule isn't within the usual run of cases. And it certainly is. It's part of the language of the Maine Human Rights Act and the Americans with Disabilities Act. This argument that transportation wouldn't be considered a reasonable accommodation is just coming at us, I believe, for the first time. It has not been questioned. So I do believe that if an individual is unable to drive because of a disability and they're asking for reasonable accommodation of a modified schedule, then that would fit the definition. But I think the question for this commission is whether or not modified work schedule is a type of reasonable accommodation, and there's absolutely no question that it is.
Thank you.
Thank you.
Commissioner David, questions for Ms. Aiello? No, okay, thank you. Thank you, Ms. Aiello. To the investigator, Ms. Brindley.
Good morning, everyone. My name is Alex Brindley. I was the investigator in charge of this case. I do want to run through some of these disputes before I'm open to any questions. So regarding the transportation issue, I don't really believe that was the crux of the issue at hand. I believe it was more the modification of the schedule, quote, that it be as close as possible as his mother's schedule. And I believe there's a little bit of disparity as to what that means. However, I mean, as Attorney Aiello said, that they they stated that they wanted it to be within 1 hour. Having the complainant sit outside for 3 hours before his shift just didn't seem to me to be that was as close as possible. And similarly, they didn't really go through the undue burden analysis. They stated that it would be difficult to schedule them at the same shift hours because the mother as a cashier works more hours and the complainant as a bagger would not. However, to me, it didn't seem that they couldn't schedule like the mother and the son for like 1 day and then the mother more days outside of their shift that they have together. And I wanted to touch on the meeting on July 30th that was brought up earlier. So I do have the 2 affidavits in front of me. I have the affidavit from the supervisor who stated that she planned this meeting after hearing about his outburst. So that led into my belief that the meeting that they had was potentially not due to furthering the reasonable accommodation conversation. And the affidavit that I have from complainant's mother, who was also in that meeting with the supervisor, remembers that the supervisor told the complainant that this isn't going to work out and you need to be able to speak with us. So that to me seemed to be that they were denying him a reasonable accommodation. And I think the symbolism of using like the wheelchair analogy works really well here, because in this case, the complainant, cannot speak. So being forced to speak and, not being able to have these reasonable accommodations means that he would be unable to perform the essential functions of his job. So he would have to resign because he wasn't provided the accommodations that he initially requested. I think that is everything that I wanted to bring up. If you have any questions, I am open to them.
Commissioner Whitworth, questions for the investigator?
No questions.
Commissioner Ashby?
No, thank you.
Commissioner David?
How many of the shifts were not accommodated of those 8 shifts?
I don't think I have a direct report of all the shifts that he worked. However, I believe 8 is around the amount of shifts that he did work before he was, having to wait outside for an extended period of time.
And there's one incident where he's out 3 hours off sync with his mother, right?
I believe so, yes. At least one incident.
Well, there's no indication of any other.
Correct.
Okay.
Okay, thank you. Next up, thank you, Alex. So we've heard from the parties and the investigator. So at this point, we would be looking for a motion or motions. Hold on, I think, there's only one reasonable ground recommendation, so a motion.
I'll move to find that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability, and that and that the conciliation be attempted in accordance with the Act.
Second.
So it's been moved and seconded. Is there any discussion?
Briefly, I'll try to be brief. From what I understand, it doesn't appear that the complainant was scheduled to work any other time that his mother was not present. And that was a big reason for the accommodation. He needed to have his mom present when he worked. But I do think that transportation is impliedly at issue in this case, because if he's scheduled to work at a time where he has to wait in order to commence his shift, the respondent's response should be, well, just find your own transportation, and then you're completely accommodated. But I think that the accommodating transportation with mother was part and parcel of the whole accommodation. And as a result, I think that's how we sort of get there. But I do think the issue of transportation is quite central to this. And that's why I asked the question about the split authorities. But I also, I think we are sort of required, absent any evidence to the contrary, and there doesn't seem to be evidence to the contrary, required to adopt the findings of the investigator. And it appears that the respondent said to the complainant, this is not working out and you're being discharged. And then rather than get official discharge paperwork, there was a resignation that does in fact constitute a constructive discharge. So those are the reasons why I find what I'm finding.
I can't support the finding. It seems to me that meeting was trying to talk about the situation. The investigator said that it's not a hostile work environment, that's not being considered. It seems to me they tried and they were trying to talk about it, and he couldn't. He perceived that differently. So I'm going to vote against the finding.
Any further discussion from commissioners? Seeing none, the motion is to find reasonable grounds to believe unlawful discrimination occurred. All those in favor for commissioners, please raise your hand and say yes.
Yes.
2 in favor. All those opposed? 1 opposed. So the motion passes. The finding is reasonable grounds, and the commission will send both parties a letter about the next steps. And we have about 3 hours to get through the remaining 8 cases. So that's a challenge. I'm going to keep encouraging folks to be as brief as possible. I don't want to cut anyone's time, but I encourage you, if you're just going to repeat what's in your written submission, just say that. We don't need to take 10 minutes to do that. If you have something new to mention not new, something you've already given to the investigator, great. But otherwise, please, I beg of you, try to keep it brief so everybody who's waiting can be heard today. Deb, you want to call the next case?
I don't. I'm recusing myself from this case.
Okay, you will not be calling the next case. I will call the next case on behalf of the 2 remaining commissioners. The next case is E190185, and it's Stephen Hawthorne versus Italian Heritage Center. Commissioner Whitworth is recused, so we have Commissioner David and Commissioner Ashby, which it is still a lawful vote, even with 2 commissioners, since we do have a quorum. So is there someone here for Mr. Hawthorne?
Just myself.
Okay, you have 10 minutes. I encourage you not to use them all.
I have no intention, but am I allowed to ask why Commissioner recused herself?
Nope. We ask commissioners if they believe that they have an actual conflict of interest or the appearance of a conflict of interest, then we ask them to recuse themselves, but it's not a matter open to discussion. All you should know is that they did not consider your case and they will not be voting on it.
All right, good morning. Thank you for your time. Basically, my appeal is the fact that I was not given sufficient time by the commission. The commission had sent me a letter telling me that I had X amount of time to prove my case. The letter that I received from the commission was received on September 9th of 2020. The instructions, wait a minute, I think I got my dates wrong. It was mailed on September 4th, and it did not arrive in my mailbox until the 9th of September. It was due to be returned to the commission by September 11th. I did not receive my mail until the afternoon of the 9th. So that basically gave me a day and a half to basically say the house was on fire, and I had to take what I had at hand to prepare and give to the Maine Human Rights Commission. I do not feel that a day and a half to prepare what has already been a very lengthy and going on 2 years of preparedness was at all fair. I did send, obviously it's been redacted, what I have sent along. I don't think you have seen it. I think there is more evidence to this case that's not being allowed to be heard, and it would have been heard had I had sufficient time to prepare. I think this case is missing one extremely important feature. I have been in the restaurant business for 40 years, both public and private. Private clubs are a completely different animal than a private club. Private clubs are governed by the members in special bylaws. In this case, the bylaws of the club is for the members. That's what they are governed under. As an employee, through the bylaws, my manager, my supervisor, is a manager hired by through the bylaws from the membership. So basically, it does not allow a member employee to butt heads. These are separate. A manager obviously manages the employees. And this is just not, it's just, I think we're missing something here. Part of my complaint was hostile work environment. This is where the hostility comes from, that a president or a vice president or someone on the board is giving precise instructions to an employee when, by instituting a manager, removes them, and I am governed by the manager. That's who I report to. That's who I am, and who, disciplines me. In 14 years of employment at this club, the board has never, ever took the role of management. I was let go by the Board of Governors. Never should have happened that way. It should have been through the manager. Does the board have the ability to instruct the manager? Yes. But the board does not have the ability to hire or fire. I've also received write-ups through warnings and whatnot through this process. It never should have been. They are also providing some of the same services as volunteers, if you will, that I do, and they're not held to the same accountability that I have been pressured to be accounted for. I guess that's basically my claim. I don't feel that I have been heard. I question the fact that this lady has recused herself. I wonder, through accusal or recusal, is, what the role is with Alex. Is this person an overseer? Is there bias involved? And if Alex continues, I think that if the finding goes in my way, that there would be continued bias from Alex towards my case. I thank you very much for you listening and in hearing, and have a great day. And I know your time is short, but thank you.
Thank you. Questions for Mr. Hawthorne? Commissioner Ashby?
None, thank you.
Commissioner David? Okay, let's turn to, is there anyone here for the Italian Heritage Center? Alex is shaking her head. She has not seen anyone. Anyone here for the Italian Heritage Center? Does not appear as though there is. Mr. Hawthorne, yes?
Just one more thing, that this did happen. The shortage of time to respond is true. I also would like to enter into the record that I received a email from Mrs. Alex Brindle that says, "Hello, Stephen, apologies. I should have postponed and postpone the close of evidence date further. Thank you for your submission, Best Alex. I'm closed. I'm done.
Okay, thank you. Let's turn next, just to clarify, none of the commissioners supervise the investigators. I supervise the investigators, just to clarify for you. Let's turn to the investigator, to Alex.
So it seems to me that the crux of Mr. Hawthorne's disagreement doesn't lie with my report, but rather the timing. I will note that my original close of evidence date was actually August 31st. I had received a final submission from the complainant, sent it to the respondent, gave them the opportunity to respond, and then in turn sent that to complainant and gave him more opportunity to respond. If complainant had told me at any time that he needed more time to respond to the respondent submission, I would have granted it. However, he did not ask me for an extension. I think that's it.
Questions for the investigator? Commissioner Ashby?
None, thank you.
Commissioner David? No. Okay, so we have heard from a complainant. There's no one here for a respondent. Is there a motion?
I'm going to move that we uphold the findings of the investigator that there are no reasonable grounds to believe the respondent discriminated against the complainant on the basis of sex and sexual orientation or retaliated against him for workplace protected activity, and the complaint be dismissed in accordance with the act.
Second.
It's moved and seconded. Is there any discussion?
I'll just be very brief. I don't think even, it seems to be it's an almost unrebutted investigator's report that indicates there's no prima facie case of sex discrimination. So I didn't hear anything from the complainant that actually challenges those factual findings in either his written submission or his comments here today. And so he may have some complaints about process, I guess. I guess he made some suggestions that the folks that terminated him or made decisions about him didn't have authority to do so, but those are not complaints proper to be raised under the act, and they don't support his claim. And that is, and the finding of the investigator that he didn't make a prima facie case, I think, is really our only inescapable conclusion.
I concur.
So the motion is to find no reasonable grounds to believe that unlawful discrimination occurred on the basis of sex or sexual orientation or retaliation for protected activity. All those commissioners in favor, raise your hands and say yes. One,
yes.
Two. Sorry, all those opposed? None, since the two of you voted in favor. So the finding is no reasonable grounds to believe that unlawful discrimination or retaliation occurred, and the commission will send the parties a letter describing the finding. And at this point, we're going to move on to the next case, and I believe Commissioner Ashby is recused in that case. So at this point, we will have Commissioner David and Commissioner Whitworth.
So we are on case E19-0355.
This is a reasonable grounds case. It wasn't starred on our agenda, but this is a reasonable grounds case.
Right.
So we would hear from respondent first.
Yes. Jenna Shaw, the Center for Diagnostic Imaging, Insights Imaging. Is there anybody here for the respondent?
Mr. Eugster was, I believe, is on the line. If you could unmute Mr. Eugster. I'm sure I'm pronouncing that wrong, but.
Close enough, thank you. Can you hear me now?
Yes, thank you. You have 10 minutes. I encourage you to use far less than that.
Yes, and I promise I will. I think the written submissions speak for themselves. I just want to make a very few points to the commission, just really to highlight our position. Again, I thank you for your time. The first point that I want to make is that despite the error of the investigators' factual finding otherwise, the claimant never fully completed an application for a position sufficient to warrant further consideration for the position. That's one. Two, and this is more important than even the first point, it is undisputed in our view that the claimant did not qualify for the position. The point there is that this per diem MRI technologist position required ART certification so that the prospective employee could actually perform all the job duties required. Now, the investigator end runs this point by quoting some comments by a relatively low-level manager talking about the certification being preferred but not required. It needs to be highlighted for the commission that that manager works in a different market and does not manage technologists that are per diem technologists. In other words, a day here, a day there at remote locations where they are performing all the job duties without the support of any other technologist team. Because of that, the ART certification is absolutely required. Otherwise, per Medicare and Medicaid regulations, and indeed some private insurers, that technologist would not be allowed, permitted legally to perform all the necessary scans and CPT codes that may be required. Essentially, this person, the claimant, did not qualify for the position in the first place, and that is because of patient care. She needed to have the certification to be able to perform all potential scans. Finally, let's remember that the investigator did not find discrimination against the claimant, but what has been found is a strained reasoning towards retaliation. And let's remember what this alleged retaliation is. The claim that the claimant and the investigator would ask the commission to believe is that Insight Health Corp, as a potential diagnostic imaging employer of a technologist, somehow retaliated against a prospective applicant for something that she did to another company who provides the same services. We simply do not know exactly what she did with her prior employer Alliance, other than one of our employees who was hired away from Alliance understood that her previous job performance was unsatisfactory. I do not think this commission should find that knowledge of poor job performance at another employer can be twisted into an idea of pretext for retaliation. I'll stop there. I thank you for your time.
Thank you for your brevity, sir. Questions for Mr. And again, I'm sorry for what I'm sure is going to be repeated mangling of your name, Mr. Huchster. Commissioner Whitworth.
I have a question. What does the job description say relative to minimum qualifications for the
If I don't have it in front of me, so I apologize for that, but I seem to remember that this job description mentioned the certification.
as required?
That's my understanding from my HR function.
Thank you.
Commissioner David, questions?
No, thank you.
Thank you. You'll have about 5 minutes left after we hear from complainant, though feel free not to use them. Mr. Hanson.
Thank you, Ms. Nearson. My name is Chad Hanson. I represent Jenna Shaw. She's on this call as well. Thanks for the opportunity. I will endeavor to keep it short. So the investigator did a comprehensive investigation. He requested documents. He actually interviewed witnesses. He assessed their credibility. And he came to the appropriate conclusion. This is a case involving retaliation against Ms. Shaw in her application because of protected activity from the past. At what we're calling the prior employer, she worked there. She was a good employee until she had her supervisor was harassing her, sexually harassing her. Eventually, she opposed it. She spoke up to her employer, and he retaliated against her by taking away all of her shifts. So what she did next is she went to his manager, who in this case is the person we call VPO. So he's the one that moves over to Insight later. And she goes to him and she reports to him about the harassment and the retaliation and the fact that he took away all her shifts, and he doesn't do anything about it. So this is the past case. And then she eventually says to him, I'm going to file a charge of discrimination. And she did file a charge of discrimination. And that went through the process and ended up in federal court, and then it resolved. And now Mr. VPO moves over to Insight. And in January of 2019, they're looking for an MRI technologist. Ms. Shaw has been an MRI technologist for 11 years. Mr. VPO during his interview acknowledged the job she was applying for with Insight was exactly the same job that she had performed at the prior employer. And she's performed it for years. She's performed it well. She can do every single image. She can do every single test. There were no issues about that. And he acknowledged during his interview that he didn't say anything about certification. He claimed that she had poor performance at her last job. And when he referenced that, what he said is that she had scheduling issues, and I'll get to that. But just to be clear, everyone, in terms of her not being qualified, she was completely qualified. Maine law doesn't require certification. It's one way of showing that you're competent, but another way of showing you're competent, especially in a rural area like Aroostook County, is to show you've done the job for 11 years. And so Ms. Shaw was able to show that. And the record shows that this employer makes exceptions to the certification requirement. And they hire people who don't have certification, and they make exceptions. And sometimes they need to make exceptions. And that is highlighted in this case. When they posted this position, when they put it up in January of 2019, Ms. Shaw was the only one that applied. There's no comparators because she was the only applicant for months. And she was qualified, and they considered her. They acknowledged that the hiring manager got a resume from a friend of hers that had told them they'd be hiring. And the hiring manager acknowledges that she saw that she didn't have a certification, but she had done the job. She'd done it for a long time. So in her mind, she could be a fit. And that's why she brought it to Mr. VPO, and he shut it down. So this is a pretext case. There are no comparators. It's a pretext case. Because the first thing that the respondent said in response to the charge is, well, we didn't hire her because she didn't file an application, which is suggesting if she had done an application, they would have hired her. And there's no support for that, because they considered her resume and then they decided they weren't going to hire her, and they later admitted that. Their second excuse was that Mr. VPO didn't have anything to do with this hiring process. But in the interviews by the investigator, they acknowledged he actually did. And he was actually the person that decided not to hire her. And so that's not in dispute anymore. But if you look at their first submission to the Human Rights Commission, the commission asked, what role did VPA play in the hiring decision? Their answer was, quote, VPO had no role in the hiring decision. So that's just not true. So why do employers make things like this up? Because they're covering up the pretext. They're covering up the retaliation, because he's the connection. He's the one that knew about her prior harassment reports, her prior retaliation claims or charge. So that's just not true. So that's the sort of pretext that proves retaliation. And again, this claim that she's not qualified, this is the same job that she's performed before. Before she performed it in Holton, she was applying for a job in Presque Isle. That's the only difference. It's a hospital-based position. She didn't need someone overseeing her or training her. She was a seasoned MRI tech, and they knew that. And they hire people like this. They make exceptions. So that's not it. Like I said before, when VPO was asked during his interview about why he he decided not to hire her, he didn't say anything about certification. He claimed that it was because of prior performance issues. And that's just not true. She didn't have prior performance issues. She was a good employee. The only issue was that she was being harassed by her supervisor at the prior job. She reported it, and then they took away all her shifts. That's the scheduling issue that he references, that she was complaining about not getting any shifts after she reported it. So the respondent, they moved from he didn't have anything to do with it, and then they moved to, well, he decided not to hire her for performance reasons. And then they say he didn't really know anything about her reports of harassment or retaliation or her charge. And so that's the place where they're at now. They're essentially saying, well, he worked there, but he didn't really know much about it. And to be clear, Mr. VPO was one of the bad actors in her prior case, the supervisor for harassing her, and Mr. VPO for not doing anything about it, for allowing the supervisor to continue to give her no shifts. So he absolutely knew about the charge and he was involved. And I just want to read, these are emails and this is part of the record that was provided during the investigation. These are emails between Ms. Shaw and Mr. VPO from her prior job. And this shows that he knew very much about her retaliation and charge. She writes to Mr. VPO, "Thank you for responding. I am contacting the Maine Human Rights Commission about this situation. Retaliation for complaining about sexual harassment, unwelcome sexual advances, rude and lewd comments, unwanted slaps on the butt, asking me to perform sexual things on him, and making me feel like I had to quit because he wasn't putting me on the schedule since I complained is illegal. He put me in a very difficult situation because he controlled my schedule and used it against me for filing a complaint." So for respondent to claim he didn't know about the harassment or he didn't know about the retaliation or he didn't know about her charge, he knew about all those things. It's in writing. And so that's the motive, is now he's got this new employer and they get an application from a qualified employee who he now knows had accused him of not doing his job as a manager. He knows someone who is alleged harassment or retaliation and filed a charge, and that's why he decides not to hire her. And all the other excuses that they've come up with since are different, and they're changing, and they're not true. So we believe that the investigator came to the correct conclusion.
Thank you. Questions for Mr. Hanson, Commissioner Whitworth?
No questions.
Commissioner David?
No.
Okay, you'll have about 2.5 minutes left, Mr. Hanson. Now we're going to go back to Mr. Eugster. You have 5 minutes. Please don't feel compelled to use them all. Oh, you just muted yourself. There you go.
Sorry about that. I'll be very brief. 2 points. Respondent stands by its contention that the claimant did not meet the specifications for the job in the first place. That's point one. And point two, I think the stretch of imputing all of, I guess they refer to him as VPO, VPO's knowledge and transferring all of whatever he may or may not know about the previous employer and ascribing it to insight on the whole, I think that's a stretch. The third and final point that I'll make is that this action before the commission, to be clear, has not named a proper legal entity. And I do not think it would be proper to have reasonable grounds findings against Insight Health Corp., who is the employer in question. The caption mixes two DBAs together that do not tie back to a proper legal entity in Maine. And I would note that because I think it's a technical deficiency. Other than that, I thank you for your time this morning.
Thank you. Questions for Mr. Eugster in follow-up, Commissioner Whitworth?
Well, I'm a little bit hung up on the qualifications for the job, as you can imagine as an HR professional. Preferring certified MRI techs, but making an exception due to the low number of qualified technicians. Was the person qualified for the job or not? Is the 10 years of experience that this individual had, does that take the place of being certified or not? And if that's in the record, I would like to know whether or not the applicant was qualified for the job.
Mr. Euster, I think that is a question for you. Wait, where did you go? Did he come off here?
Huh.
He might have accidentally, oh, wait a minute, hold on. Maybe this is him coming back. Mr. Euster, is that you? Mr. Euster?
Hi, I'm sorry. My phone dropped, so I was just trying to get back.
Okay,
I apologize.
Commissioner Whitworth was asking you a question. Commissioner Whitworth, or can you repeat that?
Let me ask it again. So question is, even though the claimant had 10 years of experience, was the qualification for the job being a certified MRI tech, or would the 10 years suffice if the person or the candidates weren't certified MRI techs? It's not clear whether or not this person was actually qualified for the job.
Yes, and my understanding is that certifications are required for certain particular types of scans or particular CPT codes. That certification can be required by the federal government if indeed the payer is Medicare or Medicaid, for example. I know that the claimant had made a point that we have hired techs that aren't certified in the past. And my understanding of that practice, if it occurs, is in a situation where there are other technologists, other boots on the ground at a particular imaging center, whereby the certified technologist can perform the scan that an uncertified technologist can't, while that particular technologist moves towards certification. This particular position is a per diem, per day position, basically out on an island. It's a person at, I believe this location was a hospital. I could be wrong there, but where this person is performing diagnostic imaging scans all by their lonesome, such that if indeed a scan came across or was referred that required certification, this person would not be able to do it. That's my understanding.
Thank you.
Commissioner David, any questions for Mr. Euster?
No. No.
Thank you. Back to Mr. Hanson. You have about 2.5 minutes. Again, feel free to cut it short of that.
I'll be really quick. Thank you, Ms. Nearson. On this issue of qualification, if you look at the regulations, there's no requirement for the certification. Under the regulations, she was completely qualified to perform all images. And like we talked about, this employer, like almost, I think all employers make exceptions if someone is qualified and that's who they want to hire. And to be clear, this is exactly the same job that she has performed for years. She performed it in Bolton. This is in Presque Isle, exactly the same job. She did it. She didn't need someone overseeing her. She didn't need someone else next to her in the room. She didn't need someone else to train her. And so that's the best evidence that she was qualified. And Mr. VPO acknowledged during his interview, the job she was applying for was exactly the same as the job that she successfully held for years. So I see that as the end of, it's just another pretext. It's one of many pretexts by the respondent to try to deflect from the fact that his real reason for not selecting her was that she had made these claims in the past. And to be clear, Mr. VPO in his interview didn't say anything about certification. He didn't bring that up. And in terms of the company being liable for Mr. VPO's actions, that's a cornerstone of employment law. If your manager refuses to hire somebody for retaliatory reasons, like Mr. VPO, like evidence shows Mr. VPO did in this case, the company is liable for that. And there's reasonable grounds to believe that that's what happened.
Thank you. Follow-up for Mr. Hanson. Commissioner Whitworth?
No, I'm going to wait and ask Mitch. Thanks.
Milo?
Milo, sorry. Milo.
Commissioner David?
No.
Okay, thank you to council. Mitch, over to you.
Sorry.
That's what we're going to call him forever now.
Oh, gosh. I'll put myself on mute.
Thank you, Executive Director. All of my ancestors are rolling over in their graves. I'm Milo Gitchos. I'm the investigator that was assigned to this case. I will open it up to questions. I think I understand where you're going to be going, Commissioner Whitworth, but please feel free to ask.
Commissioner Whitworth, questions for Mr. Gitchos?
Yeah, the issue of being qualified for the job and having the qualifications stated, whether or not you actually need the certification in order to do the job function, there is definitely some validity to the billing codes for Medicare and Medicaid, and perhaps only being reimbursed if the person holds the certification. So that's important to me.
Yes, Commissioner, I, as part of the record, reviewed the job descriptions, and in the job description itself, it does have a summary of qualifications, and under the section that asks for what is required, it has ARRT registered technologist, current and in good standing, and then ARRT advanced MR certification. Graduate of the American Medical Association, AMA approved School of Radiology, licensed radiological technologist, current CPR certification, training and experience sufficient to competently perform MR and or radiographic procedures independently. I made inquiries in the investigation as to what those certifications stood for, and it was, as I understood information in the record, and then also from complainant, that it is not a regulatory requirement. It may be a requirement, but there was back and forth between complainant and her friend, a manager, that these issues are sometimes accepted, or that the certification may not necessarily be required in all instances. The reason that I thought it was more of a case of reasonable grounds was because when complainant found out that she had not received a position or even an interview, that the certification was not an issue that had been discussed. That the discussion that occurred between her and the manager was ostensibly, well, what happened at Alliance? So it wasn't a discussion of, well, I sent it up and handed it to the hiring manager, and the hiring manager came back and said you weren't qualified. It was what happened at the previous employer. In that instance, I felt that information outweighed the certification. That whether a certification would be required or not was secondary to the fact that if the certification was the issue, that would have been put forward. And because it was not, that was my belief, all things being equal, and in light, most positive to the complainant, that it was more of a reasonable ground standard of retaliation.
That really helps. Thank you. Whoops, sorry. Okay, no, I'm not muted. Okay, thank you.
Commissioner David, questions for the investigator?
No, I agree. It's helpful. No further questions.
Great. Thank you, Mr. Gitchos.
That's Mitch.
Yeah, that's what it will be. So we've heard from the parties and the investigator. Is there a motion or motions?
I'll move that we find there's, take them together, there's no reasonable grounds to believe there was sex discrimination, and that complaint should be dismissed, and that there are reasonable grounds to believe there was retaliation, and conciliation should be attempted.
Second.
Speaking for the motion, Attorney Guster said that it was a strained connection with the prior complaint. It's not strained at all. It's an absolute direct connection with VPO. It seems open and shut. And in terms of the qualification, that seems more of a pretext that it may be true, it may not be true, but one believes that these things would have been discussed up front, and one also believes that exceptions are made for one of the most rural counties in the country, with finding somebody to do the job and making exceptions, or getting somebody else to review it if there's a scan that needs to be, or something like that. So I think it's clear.
Any additional discussion? Seeing none. So the motion is to find no reasonable grounds based on sex and reasonable grounds based on retaliation. All those commissioners in favor, raise your hand and say yes.
Yes.
I see 2 in favor, and since that's all of you, there are no opposed. So those are the findings, and the commission will send council and the parties a letter about those votes and about the next steps. Thank you, and moving swiftly on.
Thank you.
Case E19-0415, James Williams v. First Vehicle Service. This is not a reasonable grounds case. So is there anybody here for the complainant?
I believe Mr. Williams was here. Oh, there he is. Okay. Okay, Mr. Williams, do you want to unmute? I think you have to tap it on your computer.
Oh, we do
There you
now.
go. Okay, you've got 10 minutes. I encourage you, if you're, keep it brief. If you're just repeating what's in your written stuff, don't. Okay.
I'm making a disagreeing with the investigator, saying that it only happened once, which it came back as that the information was new and it was redacted, which you had the information for 10 months, which you received, and got a letter from you on the 16th that showing that there's more than one incident happened at work. Also, it shows that it was U-turns going down a one-way street, also going movable sand, which is silica, needed a mask. And every day I went to work, when I first called in about the crew leader, he gave me a hostile environment every day I went to work. And also on the reports that he didn't list, that I had an affidavit from another crew leader showing the kind of retaliation I was getting from the crew leader. Also, I didn't mention that I got a report for the time I called the hotline, the date, and I got a write-up after that day. I did not have any write-ups at all whatsoever. And also, I disagreed that he said on his report, when it said on the 5th, when I had that meeting, that I didn't come back to work. Well, my last day of work, when I was told, was 10/10/19, not the day it says on his fact finding that my last day was 10/10, not June 5th. So there's just a lot of information that he put in. It was more than one incident. I'm keeping it short.
Thank you. I appreciate that very much. Let me hold on. Commissioners, questions for Mr. Williams, Commissioner Whitworth,
No questions.
Commissioner Ashby,
Thank you.
Commissioner David.
Nope.
Okay. You do have time left after we hear from respondent if you want to use it, Mr. Williams, but for now, just hold on. I don't know if I have seen someone here for respondent, but Deb, you want to call them, or do you want me to, since I'm super controlling anyway?
Is there anybody here for the respondent?
First Vehicle Service. Ms. Schisler was representing them throughout the case, but I haven't seen her on here. And I don't know if they took on someone else. Is there anyone here for First Vehicle Service? Apparently not. Mr. Williams, do you have anything else you want to add?
Just that showing that when I disagree with the investigator, you reported back why I dispute. You came back, it was new information and it was redacted, which you did receive. You did receive the information 10 months ago. I just wondered why you only put down, it was only one incident that took place on his report. Is that information still redacted?
Yes, it is still redacted.
So even, did you receive all the information from I sent on January 13th?
Mr. Williams, when someone submits a post-report submission, the investigator reviews it in detail to see if everything is in the record. The investigator concluded that many of the things in your submission were not in the record.
According to your letter on January 16th, you did receive my rebuttal, which he did say he received the tape, which included all that information.
The investigator indicated that the redactions stand. So we don't agree that you submitted all those things before, but this is not the time. We're at the hearing now. We're not going to change our minds. The redactions stand. So if you have something that's not redacted.
Oh, okay, I do have one redacted. On the rebuttal on the phone calls that was made, had incidents showing about the U-turns and the way he was driving that was not redacted from the phone calls he had with the first vehicle. That was on the 28th. On the 28th, when he had the phone call with the first vehicle with Schuster. Also had that information showed that that he left out, that he only showed it was only one incident that he made U-turns going one way. There was safety of, of my safety and the harassment at work every day while I was there. And Schuster did not do nothing until I called the Tigray hotline, and that's when I got the writ up. That's it for now.
Okay, thank you. Any follow-up questions for Mr. Williams? Commissioner Whitworth?
No questions.
Commissioner Ashby?
No, thank you.
Commissioner David? Okay. So at this point, since there's no one here for respondent, we will turn to the investigator. Mitch, once again, over to you.
Right. I'm investigator Mitch Gitchos. I need to call my mom and let her know that. I was assigned to this case. As a background matter, commissioners, let me just kind of clarify the record a bit. Complainant began at a new location and had an incident or had with a team lead, a supervisor of him, if you will, and believed that he was engaging in unsafe driving. Complainant informed their supervisor of what he witnessed. Supervisor took it into account, spoke with the lead, and Later, the lead became hostile with complainant. There continued to be hostility between complainant and his supervisor, and complainant continued to inform the supervisor, I'm sorry, there was continued conflict between complainant and his team lead. And complainant continued to bring these issues up to the supervisor. However, at one point, there was some sort of physical altercation between complainant and the team lead, where the supervisor had to stand in between the gentlemen, and other people there had to separate them or keep them separated. After that, both men were put on different shifts and separated and kept apart. The complainant did put in a phone call to the integrity hotline and did meet with a representative from Human Resources and his supervisor regarding the issue, and was given a write-up at that time for the conduct that occurred when they had to be separated. Shortly after that is when, as I understand it, complainant found work elsewhere or left his position. That's a general sketch of the record. Any questions?
Oh, filling in for Amy. Any questions, Commissioner Whitworth?
No, no questions. Thank you.
Commissioner Ashby?
Yeah, Investigator Gitchos, that explanation was helpful. I had questions about the fact that the complainant seemed to have been disciplined on May 28th by having this reassignment to a shift that paid less, and then thereafter was apparently on June 5th given a written warning for that same incident. I couldn't understand why. So are you saying that your investigation showed that his reward, I guess, for calling in to complain about his unfair treatment on May 28th was to get sort of a more formal written discipline? It seems to be almost what happened.
As I understood it and reviewed the tape, or there was a tape that was submitted by complainant, and I listened to it, and it was a write-up with HR that, as I understood it, Commissioner, they were playing catch up on the paperwork, that they had moved complainant and the other gentleman to day shifts, and in the paperwork for the move to day shift needed to be finished. And that was this write-up, that they had been warned beforehand that you're going to have a write-up coming, you're going to have paperwork coming. And it just seemed to coincide essentially with his complaint to the integrity hotline.
And your footnote 9 seems to indicate that the nature of the call to the hotline was to complain about his treatment being moved to the day shift and not to raise new sort of whistleblower or protected under the act complaints. Is that correct?
That's correct.
Otherwise, it would be challenging, right? If he in late May or early June made a call and made additional complaints and then got an additional discipline for something he'd already been disciplined for, it'd be a different case, right?
Yes.
Thank you. Your contributions right now have been very helpful. I'm all set.
Commissioner David, questions for the investigator?
No.
Okay. Thank you, Mr. Gitchos. So we have heard from the parties and the investigator. Is there a motion?
I'll move that we find that there's no reasonable grounds to believe there was retaliation and the complaint should be dismissed.
Second.
It's been moved and seconded. Is there any discussion? Nope, not from you, Mr. Williams. This is just for commissioners at this point. Seeing no discussion from commissioners, the motion, oh, I'm sorry, Mr. Ashby?
No, I was just waiting to.
Okay. The motion is to find no reasonable grounds to believe unlawful retaliation occurred. All those commissioners in favor, raise your hand and say yes, please.
Yes.
Yes.
1, 2, 3 votes. So it's unanimous, no reasonable grounds. The commission will send a letter to the parties outlining the process from here. Thank you, Mr. Williams. We're going to move on because we have, I think, 4 more cases. And I'm hoping to get to everyone today.
Amy, even mindful of that, I would move we recess for just 3 minutes.
That is understandable. It's been quite a while. So 3 minutes. Thank you.
I'm back, thanks.
Okay, now we just got to make sure we have the other 2.
I'm here.
Okay, I see 3 commissioners. Excellent. You want to
Okay,
call
so our
the
next case?
Yep.
Yep. So E19-0470, a reasonable grounds case, Dr. Anne Marie Lemire, the Armor Correctional Health Services, Inc. Is there anybody here for Armor Correctional Health Services?
Hi, this is Laura Rideout. I am counsel for the respondent, Armor Correctional Health Services. And joining us on the line this morning is also a company representative.
Great. Thank you, Ms. Rideout. I encourage you to keep it brief. You have 10 minutes.
Thank you. I will do my best. So what I would like to focus on this morning is basically 3 topics that were raised in the objection to the investigator's report. The first has to do with the timeline that was evaluated in support of the conclusion that there was retaliation. And Armor respectfully suggests that the timeline that was examined was fairly narrow. And if we sort of extend that timeline out, we're going to have a slightly different picture that's painted for us. The second is the fact that there is extensive evidence in the record supporting the legitimate grounds for termination, especially voluminous emails. And these documents were not analyzed in the investigator's report. And finally, I want to talk about the legal standard for protected conduct. And there are a few factual details that I want to highlight in connection with that analysis. But the main point is that this is a case involving an employee who was venting about the company and making disparaging comments about the company to clients and to subordinate staff members. And it's really clear that this is unprofessional behavior, it's inappropriate, and an employer is well within its right to decide not to continue employment with an individual who's engaged in this type of behavior, especially after the employee has had the opportunity to sort of receive some constructive feedback on that and has made the decision not to change ways. And this is exactly the conduct that was happening here. In order to contextualize all of this, I want to provide a little bit of background information. So the respondent is a company that is physician-owned and minority-owned and provides health services to patients in prisons and jails across the country. And the respondent entered into a contract to provide these services at the Cumberland County Jail in 2018. Now, the complainant was the on-site medical director at the jail at the time, having been employed by respondent's predecessor. And the complainant continued on in that role as a legacy employee once Armour took over the contract. These types of transitions, when one entity is sort of coming in and taking over these contract obligations and responsibilities from a predecessor, can be fairly tumultuous for legacy employees. There's new management coming in, there are new standards, new expectations. There's going to be some turnover and vacancies to fill, changes to administrative procedures and protocols, and new expectations for clinical operations. And so it can understandably be fairly frustrating for these legacy staff members who are sort of used to doing things one way or another way, and who are all of a sudden being told that they have to change the way they're doing things by this new management that's coming in. So that's sort of the overarching context for all of this. Dr. Lemire was disgruntled throughout this process, and respondent really needed its on-site leadership to help implement these changes and to sort of set the bar and be a model for a positive attitude. But what we see here is that the opposite was happening, and complainant was really fanning the flames with on-site staff during this transition period and was exacerbating morale problems and engaging in some fairly problematic client communications. And I tried to be fairly thoughtful with how I walked through some of these problematic emails in the objection to the investigator's report. So I won't go into all of those details now, and I won't belabor what was said in each and every one of those emails. But what we're seeing in those from a general standpoint is an attitude being conveyed that it is the instructions being received from Armour are something that I can disregard, and it's okay for me to work around Armour. And very disparaging emails sent to the company's client indicating that the company was disorganized and was in disarray. Negative comments that were very critical of respondent staff members, encouraging the client to look into litigation that the company was involved in. And most problematic of all was the fact that complainant continued to engage in these types of inappropriate communications, even after she had been counseled in writing in an email in May of 2019 by the then chief medical officer that you are a representative of the company and you need to be a little bit more thoughtful about how you're communicating with the client. So the company was well within its right to part ways with an employee who was deliberately disregarding these instructions and exhibited a pattern and practice of doing this for many months prior to the termination, especially where this insubordination was affecting its ability to make traction during this difficult transition period and was undermining the client relationship. Now, the investigator has pointed to two instances, where the complainant was engaged in protected activity under the Whistleblower Protection Act. And ARMOR respectfully suggests that if we sort of examine some of the factual details surrounding those two incidents, the conclusion is not supported that this was actually protected activity. So we're talking about the September 2019 town hall meeting, and we're talking about an email that followed the following month on October 8. And both of these complaints had to do with staffing issues in the medical department at the Cumberland County Jail. So the first problem with this is that the investigator looked at a timeline of these two complaints and then noted that the termination was later that month in October. And so the timeline here is supporting retaliation, but there's no discussion whatsoever of all of these other, the significant volume of problematic emails that had come before, during, and after these events that were sort of going on behind the scenes and were the factors that led to the decision to terminate. And the other problem is the lack of contemporaneous evidence showing that the complainant felt that she was bringing an unknown safety issue or dangerous condition to ARMOR's attention. When these complaints were made, the contemporaneous documents make clear that complainant was focused on employee morale impacts and never provided any specific factual information to tie any problems associated with staffing to a safety condition or a dangerous condition that was happening on the ground in the Cumberland County Jail. And these are the types of things that, if they were happening, should have been immediately reported to the chief medical officer, because they're examples of basically failure in a clinical operation. And most telling here is the fact that we know complainant availed herself of the opportunity to complain about these types of matters via email. So the fact that there's a dearth of evidence of any reference to safety or dangerous conditions is especially instructive here. The other issue I want to talk about is the reference to the recent Pushard case. The investigator seemed to reject that was an analogous case here, and we respectfully suggest that it is something that should be taken into consideration as a similar result in a similar case, where the employee in Pushard was raising concerns about staffing and was effectively complaining about supervisors' decision-making on how to handle a staffing shortage issue. And that's exactly what we have here, where complainant was complaining about staffing shortages, was referencing impacts to employee morale, but complainant has admitted in the charge of discrimination and in the other submissions that this is something that ARMOR was already aware of. And the timeline certainly shows that this staffing issue was on respondents' radar. It was something that was being addressed and communicated about. And even these emails from the client contact at the Cumberland County Jail made clear that this was something that the parties realized was going to take some time to work out. So the bottom line is that an employee is not shielded from the consequence of these types of inappropriate and unprofessional communications with clients and otherwise, even if there was protected conduct here, which we dispute that there is. And for these reasons, respondent respectfully asks that the commissioners evaluate this broader timeline, reconsider application of that legal standard for protected activity, and find that there are no reasonable grounds to conclude that retaliation occurred here.
Thank you, Ms. Rideout. Questions for Ms. Rideout from commissioners? Commissioner Whitworth?
I just have a quick question. There seems to be contradictory words. Says that in your submission against the determination, it says that she was counseled about the company's reporting structure and appropriate client communications. However, in the report, it says that the investigator requested the personnel file and there was no written documentation relative to counseling.
So that's correct. So there's no written disciplinary action in the personnel file. The documentation where the complainant was counseled on this issue was an email communication that took place in May of 2019. And this email communication was attached to complainant's May 2020 submission. So it wasn't documented in the personnel file in a a written disciplinary action form type of document, but it's certainly in the record as evidence of the complainant being put on notice about the behavior being unacceptable and then choosing to continue to engage in a practice that was inconsistent with the instruction received from a higher up.
Thank you.
Commissioner Ashby, questions for Ms. Rideout?
I don't think at this time, thank you.
Commissioner David?
No.
Thank you. Ms. Rideout, you'll have about 30 seconds left once we hear from complainant.
Thank you.
I believe Mr. Boots is here for complainant.
Yes, I'm Paul Boots on behalf of Dr. Lemire, who I understand is on the line as well.
Okay. So who's presenting for Dr. Lemire?
I am Paul Boots.
Okay. So you have 10 minutes, so though I encourage you to use less than that.
Okay, thank you. The complainant is a medical doctor who has spent her entire practice working with the disadvantaged poverty population, HIV, Ebola. She's a doctor who has put her practice, has dedicated her practice to helping the disadvantaged. She was working at the Cumberland County Jail prior to the respondent taking over the contract. I believe she was there in 2017. And I'm going to focus on a couple of things respondent brought up here. Respondent tries to characterize the email from May of 2018 as some sort of disciplinary action because there obviously is none in the record. The only contact was at the directive of Dr. Hughes that she should be
Mr.
cautious.
Boots, please don't use the names of any witnesses or third parties. We've given them other pseudonyms in the report.
Very good. She took that caution seriously. She was in the middle of working with to implement at the Cumberland County Jail the medication assisted treatment program. And that was somewhat outside the purview of the contract, but she took that directive seriously. And the characterization that this instruction was somehow sort of a disciplinary action is simply not the case. The record is completely devoid of any disciplinary action, and the investigator looked at this, asked for the personnel file, interviewed several witnesses, and asked for additional information. And the investigator properly found that there simply was nothing they're now trying to characterize her as being a complaining, unhappy employee. But there's nothing in the record to support that conclusion. There ultimately is in the record the complaints that she ultimately did convey to the Cumberland County Jail about the level of staffing, which had reached a critical level. I think you'll see in the record 52%, 54% along those lines, and ultimately did bring those concerns to the attention of the Cumberland County Jail. Now, the timing of her termination, I think, is important to look at. This termination took place. She was forcibly removed from the premises by members of the respondent. I think it was the 21st of October 2019. That's after they had the meeting at the Cumberland County Jail, which was to air concerns and grievances, and the complainant certainly did that and was told there would be no repercussions for that. This took place after she had made Cumberland County Jail aware of the concerns that she had. And also, I think the timing, and I think what leads to this pretextual conclusion on the part of the investigator is also, this isn't referenced by the investigator, but the timing is important because she was removed from the Cumberland County Jail, I think it was a day before or within 2 days of an accreditation meeting or hearing that was to take place on the contract that is run by the respondent. And I think it's clear, at least our position is that it's a fair inference to draw that the reason they forcibly removed her from her position was to get her out of the way for this accreditation hearing. And that is additional information that I think the investigator used to conclude that this was simply a pretextual discharge for claiming that she was somehow, a complaining employee, an unhappy employee. What she was unhappy about was the level of staffing. There were promises made that the staffing levels would be addressed, and they simply were not. And that information, ultimately, she felt that was jeopardizing client services, putting people at risk. And in terms of not having demonstrated anything about what that risk was, I would address you to the complainant's submission, where she outlines in her submission the information that she brought forward, discussing what individuals had been put at risk in a specific way. She talked about one individual who was in a florid state of renal failure. She talked about psychiatric issues that had occurred that had not been addressed due to staffing. And she talked about a near-death case and how the nursing staff had been affected by that. So it's not as if she didn't use examples of how the staffing levels, the inadequate staffing levels, impacted the standard of care which was being offered at the Cumberland County Jail. So I would urge you to adopt. The investigator reviewed this information, made conclusions about credibility, as a matter of fact, in terms of the witnesses who were interviewed in this process, and found that there are reasonable grounds to believe that the claimant was terminated for protected whistleblower activity. Thank you.
Thank you. Questions for Mr. Boots? Commissioner Whitworth?
No questions, thank you.
Commissioner Ashby?
None, thank you very much.
Commissioner David?
No.
Okay. Mr. Boots, you'll have about 3 minutes left after we go back to Ms. Rideout for her 30 seconds, if she wants to use them. Oh, you're muted.
Sorry about that. Just briefly, as I mentioned in my initial remarks, I think it's especially telling that the first time we're seeing any reference whatsoever to impacts on patient care, this reference to a patient with renal failure and this other reference to a near-death case, it's especially telling that we don't have any reference to this in the contemporaneous documents. And in complainant submissions, we don't have any information tying these problems to the staffing issue. It could have been something else, like a charting issue or experience of the staff.
Ms. Rideout, I'm sorry. I hate cutting people off mid-sentence, but that's your time. Sorry. Follow up from commissioners. Commissioner Whitworth?
Nope, no questions.
Commissioner Ashby?
None, thank you.
Commissioner David? Nope. Okay. Thank you, Ms. Rideout. Mr. Boots, you have about 3 minutes left if you want to use them.
I have nothing else to add. Thank you very much.
Perfect. So at that point, we turn to the investigator, Ms. Thompson-Crossman.
All right, good afternoon now. Kit Thompson-Crossman again, as the investigator assigned to this case. A couple of things to clarify, and then I'll be happy to answer your questions. So it's true that complainant did not specifically mention like individual patients and what she was concerned about with regard to them, but she does frequently refer to the critical levels of understaffing. And she does mention errors that are being made in an email to the chief operating officer. So while it's true that she's not making specific, that she's not referencing specific patients, it's clear that she's concerned about the safety and general like operational capacity at the jail. So that seemed clear to me to be WPA protected reports. She did receive an email from the chief medical officer about emailing the client. That was primarily, as Attorney Rideout pointed out in her submission of disagreement, that was primarily about a medically assisted treatment program, not necessarily, the CMO was not talking to her about making these reports to sheriff. And after that email in May of 2019, she was not spoken to again about her attitude or about her reports to sheriff. And she actually didn't make that many more reports to sheriff after that. And mostly the information she gave him were in response to emails he sent her. She didn't initiate those conversations. I think those are the only things I wanted to clarify. I'll be happy to answer any questions that you have.
Commissioner, questions for the investigator? Commissioner Whitworth.
No questions.
Commissioner Ashby.
Oh, thank you.
Commissioner David.
No, thank you.
Okay, so we've heard from the parties and the investigator. Is there a motion?
I'll move that we find there are reasonable grounds to believe that the respondent retaliated against the complainant for engaging in WPA protected activity, and conciliation should be attempted.
Second.
It's been moved and seconded to find reasonable grounds. Any discussion?
Very briefly, I think we're entitled to the inference that she was complaining about patient care. I'm not troubled by the fact that there's a lack of specificity in those complaints. I don't know whether it's an appropriate policy or not, but I don't think it's fatal to the complainant's case that she made complaints directly to the sheriff, who I understand runs the actual jail. So I think that it would be interesting if she didn't make complaints to the sheriff. I agree with the recommended findings by the investigator that this case is not analogous to the Riverside case, which was a case of much more, as I understand it, much more common understanding in more public reports than what was happening allegedly in the Cumberland County Jail. So for all those reasons, I support Commissioner Davis' motion.
And speaking for the motion, I can't get by the fact that the respondent's complaints about the disgruntled employee or that she's being insubordinate and continuing to make the complaints is anything more than not wanting to hear the complaints. I'm also not troubled by the leakage over to the client, to the jail. She's a doctor. She's reporting unsafe conditions. Clearly staffing and the ability to treat patients is directly related to patient care.
Well, she's not just the doctor, she's the director, and that's significant. And that finally, I didn't mention this, but I'm moved also by, of course, the timing of the termination and the shifting explanations for the posting of her job within hours or days, I guess, within hours, I'm sorry, of her making her complaints to the COO.
Okay, so the motion is to find reasonable grounds to believe unlawful retaliation occurred, protected whistleblower activity. All those commissioners in favor, please raise your hand and say yes.
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 1, 2, 3. It's 3-0. The finding is reasonable grounds. The commission will send the parties and counsel a letter We have 3 cases left. I believe we can do this. I encourage folks, continue with the brevity.
Okay, our next case, E19-0498, John Walton v. Oxford Casino. Is there anybody here for, so sorry, it's not a reasonable grounds
Mr.
case?
Walton. Mr. Walton is
Yeah.
in fact here, I believe.
He's not here. Oh, he is here. Okay.
Yes.
Thank you.
Okay, Mr. Walton, you've heard me say it. You have 10 minutes. Feel free to use a lot less.
Okay, yes, I will do my best. The casino is such a highly regulated industry. There's a lot of things that are tougher to understand, but just to welcome Commission. Thank you for giving me the time. I was a table game shift manager. On April 5th, 2019, there was an incident that happened. A table fill came out and it was the wrong amount. I was a shift manager on duty. It was the wrong amount that what was stated on the document. The chips, they didn't match the document. The error wasn't noticed, the fill was put in, and all that paperwork was dropped into the table drop box. And to shorten it, the amounts that were wrong were there were supposed to be $60 and $1 chips, and there was $300 in $5 chips, which would still be 60 chips. So that's where the miss was by security and in the fill and in the fill bank and everything. So now this is the first time that it ever happened since Oxford Casino has been open. There's no procedure for handling this since it was the first time. There is a similar procedure for handling a fill that goes to a wrong table. And this procedure, which was approved by the VP GM, it states to generate a document of paperwork only. Okay, so which would be a false document, and it's for audit clarification. Now what I did is I did a workaround to try to fix this situation. I instructed the cage to generate a fill for the $60 in chips and the $1 chips, and then I generated and all.
Mr. Walton, I'm so sorry. Could you pause for a second? I think the investigator got bounced off of the meeting and she's coming back in. Can you just hold on? I paused your time.
Yeah. Okay.
Okay, so there's the investigator. If you could just go back maybe 30 seconds.
Yes. Okay. All
Okay,
right, we'll
thank
do.
you.
All right. So, yeah, the procedure for when a fill goes to a wrong table is to generate a document for audit clarification. So audit knows what is going on. And in that particular situation, you actually send out the paperwork only stating these chips are going to a table. So it's actually a false document, but this policy was approved. So I instructed the cage to generate a fill, in this case for the $60 and $1 chips, and with that generate the paperwork for the $300 and $5 chips that was already sent out. And all this was for audit clarification, and also so the chip bank would be able to balance their inventory at the end of the night. So basically, everything would match up. So as I mentioned, this was a workaround. Everything was reported to surveillance, so they knew what was going on. They were reported to security, exactly what was going to happen. Nobody lied. There was nothing egregious that happened. Nobody stole. No money was missing. Nobody was trying to hide anything. Oxford Casino thought or accused me of actually covering up the first violation that happened. So afterwards, after this was all done, I reported to my supervisor, who then failed to report it to the compliance director. So it made it seem like I didn't report it. So I figured, based on the fact that there's really no procedure for for this incident, I performed what I believe to be the right situation. Again, since it never had happened before, there was no cover up. Okay, this procedure was for a fill to a wrong table. It was adopted in March of 2015, and the reason why that particular policy was adopted was because a fill went out to the wrong table 2 separate occasions, which would be an internal control violation both times, but nobody was terminated for that. So was the way I handled this incident right or wrong? I don't believe that even executive management knew at that time whether it was. I wasn't vague in any of my reporting. I followed all the steps going through. In fact, there was a policy that was adopted after the casino terminated me about how to handle that particular situation. So as indicated in my submissions, the age, gender discrimination, it actually goes back further. It's not just in this investigation done by HR. It goes back to, first of all, there was a sign violation that you'll see in there. When a table limit sign goes out, all play is supposed to stop. So if it's electronic malfunction. Now, a shift manager has never been written up for a table sign violation. It's always the floor supervisor and the dealer are the ones that are responsible for that. They're responsible for that proper signage. Now, when the GM, when the VP, he's both, he found out that where people were getting written up for these signs going out, electronic malfunctions, he wasn't happy. In fact, he rescinded some previous write-ups. I had a write-up in there that for a sign going out, and I'm a shift manager and the reason why the sign went out is because I was processing a jackpot, which was somewhere in the vicinity of $100,000 that a patron was going to be getting paid out. So the sign went out on a bunch of different tables. Well, one dealer decided to start dealing because the sign was rebooting, and I was actually standing next to the table at that time because I'm processing this jackpot. So I got written up for this violation. The shift manager, again, is never responsible for that. No other shift manager has ever been written up for anything like that. In fact, now, or shortly after this violation that I had, there was a disclaimer actually put on every table that if a sign malfunction, the table limit will revert to the $5 minimum. So thus eliminating any future violations of that nature. Also, another violation I had was that they used against me when it came to this final internal control violation was that a currency transaction reporting, CTR violation, when it happened first at the cage, and I was the only one that was written up for this violation. There was other people that were involved in it. In fact, like I said, it happened first at the cage. Then I was given inaccurate information by one of my fellow shift managers that this person was okay as far as their buy-ins at a table. They can't, if they exceed $10,000 in buy-ins, we have to have all their information, Social Security, W-9, everything. So this person didn't have it. I was given information that they were all complete. This shift manager leaves. Now this person buys in at a table and they're over the 10,000. And because I okay it, because I was told that everything was fine, I get written up for this. I was the only one written up for that, even though there were others involved. And then another thing is, that I mentioned in my submission is the shift assignments, where Oxford Casino claims there are no shift assignments. Shift assignments are actually specific to each department, and table games had their shift assignments for their shift managers, they were done on a yearly basis, which is typical any casino across the country. I've been in the casino business for 20 years. I was in a casino before Oxford Casino opened, so it is typical for that to happen. I changed my shift yearly. There were others that didn't always do it for whatever reason. And one specific example that I cited in my complaint was that one female shift manager, she worked the same shift for 4 years, and that was the day shift. I actually had asked, I asked my supervisor December of 2018 to not be moved to grave shift. That was a 1 a.m. to 9 a.m. Shift, as I had just had surgery in November. I would have some, I just have less discomfort and pain for a period of time if I was working the 9 to 5 shift. And it was really my turn to be able to work the day shift. But that request was denied, and my supervisor told me that I should just apply for FMLA, which wouldn't help that situation.
Mr. Walton, that's your
Yes.
10 minutes. That's your
How
10.
much?
10.
Okay.
All of them.
All right. All right. Thank you. And I'll be happy to answer any questions that anybody has. Thank you.
So commissioner questions for Mr. Walton. Commissioner Whitworth,
No questions.
Commissioner Ashby,
None, thank you.
Commissioner David.
No.
Thank you. To Mr. Bauer, I believe.
Thank you very much. Can you hear me all right?
Yes, feel free to keep it brief,
Okay,
sir.
great. Thank you, I will. On behalf of Oxford Casino, I really appreciate the chance to spend a few minutes with the commission today discussing this case. Thank you. This is not a case about whether or not internal controls were violated. And as Mr. Walton points out correctly, the casino industry is highly regulated. Because it's a cash business, there's a lot of cash flowing through the casino every day. And it's important that that cash be tracked, because it's so easy to see how it could be diverted inappropriately, both to the detriment of the casino, but also to the detriment of the government that is receiving tax on the proceeds from the gambling operation. So the state has a very direct interest in this, as well as the casino. And as a result, there are these very technical internal controls procedures that govern how the money is moved through the casino and how the chips are managed. And that's the basis of this case. So this is not a case about whether Mr. Walton violated the internal controls that are appropriate in this table fill situation. He agrees with it. The evidence all supported it. There was an incorrect fill put to the table that got signed off on by all the people involved, including Mr. Walton, and that was not correct. That's an internal controls violation. But then the second one is the one that really got everybody excited, is when instead of filing or producing the error notification slip, the so-called ENS slip, he decided to fix it, as he just pointed out to you, and to what he also said to the investigator for the company, cover people's butts. And so he, instead of fixing it with the ENS form and telling everybody what happened so that there could be an appropriate, auditing of the paperwork that would create appropriate audit information, he, like perhaps a baseball umpire that gets the call wrong at first base for one team and then decides to fix it by calling the next one wrong the second time, you just can't do that. And so he, basically created a second false set of checks or poker chips and put them on the table and signed off on those as if that was accurate, and put that in the Dropbox to try to match it up and balance it out. And so that creates the biggest problem, because not only is there a second incorrect fill signed off on, but there's also now, an intentional misrepresentation of the facts, and that just couldn't be tolerated. Now, this is he admits all of this information, most of which he's talked about already, but this is really a case about proportionality of discipline. He was terminated. He takes offense to that, but he speculates without really any evidence that others, and he didn't even mention this today in his oral presentation, that other younger or female employees in the same situation would not have faced the same discipline. There's simply no evidence of that. And so I think what the investigator found in this case is 100% correct, that Mr. Walton does not make out the prima facie case for retaliation. He doesn't show that he was discriminated against because of his gender or age, and he was not performing his job adequately, and therefore he just doesn't get past the prima facie burden he has. Even if he did, the evidence supports the fact that he mishandled the situation, and there's no real evidence that the casino put on evidence of why the action was taken. He has not rebutted that adequately, and so I think the investigators' findings are exactly correct, and we'd ask that you affirm the investigators' findings and conclusions. Thank you.
Thank you. Questions for Mr. Bauer? Commissioner Whitworth?
No questions.
Commissioner Ashby?
Thank you, Mr. Bauer.
Commissioner David?
No.
Okay. So then we would turn to the investigator, Ms. O'Reilly.
Good afternoon, commissioners. Can you hear me okay?
Yes.
Okay, excellent. Had to switch devices there. Apologize for that technology error. So I was the investigator on this case. I don't have a lot to add. I think a lot of the factual information that both parties presented is directly addressed in my report. I'll just summarize and say that, again, the sort of defining part of my analysis in this case was that while complainant did disagree with how the issue should be handled and how he was disciplined, respondent's decisions on how it handled the situation, how it did discipline complainant, were not discriminatory in nature. They simply followed their policies and would have done so with any other employee. And I'm happy to answer any questions.
Questions for the investigator, Commissioner Whitworth?
No questions.
Commissioner Ashby?
I just have a couple. I'll be quick. So the gender discrimination claim, I'm not sure I even understand what the prima facie claim is. Were there comparables? Did the complainant present some evidence that others had been treated differently than he had been?
Other than his assertions, no. So you're correct. It's very confusing, and it was a very sort of weak presented case initially. The crux of complainant's claim was that he had heard of other female employees who had requested specific shifts. I believe it's in one of the footnotes on the first page. A female employee had asked, because she had a family, could she be on a different shift? And he asked also if he could be on a different shift for a different reason. He had a back injury and he felt more comfortable working a different shift. And respondent's response to my questions was basically, they don't have a specific policy. They just rotate the shifts and uses their discretion based on whatever that discretion is. And I did not find anything additional in the record either from complainant that there was any reason to believe those decisions were based on his age or his sex. So
secondly, what, again, just on prima facie claim, what is the WPA even claimed?
So it's not a WPA retaliation claim. It's an MHRA retaliation claim.
Oh, I'm sorry.
I think.
Okay. So
hold on. Yes. So the complainant, firstly, his initial claim on his complaint form was an MHRA retaliation claim. However, I do address, had it been a WPA claim, which would have been the correct style of protected activity, again, reporting an unsafe or illegal condition. What he reported, this is footnote 3 on the first page, was that he reported 2 other employees for policy violations, similar to the types of policy violations he was engaging in. And I determined that that was not protected activity because he was simply reporting some counselings he'd done as a supervisor.
Okay, thank you. That clarifies things. Thank you very much.
Yes, of course.
Continuing in that same vein, that there's very, very little allegation of sexual discrimination. There's none at all of age, is there, Jane? I don't see anything about age.
Again, the basis of the claim that it was age discrimination lacked any substantive support in the record. Complainant's main arguments were about how he disagreed with the type of discipline he received. He disagreed that there was a policy in place. He disagreed. He did actually make the assertion today that that no other employees were disciplined as a result of these final two control violations with the incident with the fill. That's incorrect. Multiple employees were disciplined as a result. They were simply disciplined based on their level of involvement, whether they were directed by a supervisor to gauge the behavior, whether or not they'd had previous violations. And so all of that was justifiable based on things other than an age or a sex discrimination claim.
Okay, thank you, Jane. Is there a motion or motions?
I'll move that we take both findings together and that we uphold the findings of the investigator that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of age and or sex, and no reasonable grounds to believe that the respondent retaliated against the complainant for engaging in MHRA protected activity, and that the complaint should be dismissed in accordance with the act.
Second.
It's been moved and seconded. Is there any discussion? Keeping in mind that we still have 2 cases and executive session to get through in the next hour and 15 minutes.
Yeah, it just seems to me that we're being asked to second guess the casino's procedures, all of which sound reasonable in the face of the fact that there's no substantial evidence of any discriminatory activity. If there were, then we'd be saying, is this pretextual? But that's not true, and they all appear to be legal requirements. He's a victim of the fact that the cover-up is worse than the offense, but that's not, that's the casino's decision.
Thank you. So the motion is to find no reasonable grounds on the basis of age or sex for discrimination, and no reasonable grounds to believe there's MHRA protected activity retaliation. All those commissioners in favor of both no reasonable grounds findings, please raise your hand and say yes.
Yes.
That's 3. And since that's all of you, that means it is unanimous and both findings are no reasonable grounds. The commission will send a letter to the parties and council. Now we have our second to last case.
So H20-0342, Angela Verge, whose guardian is Diane Sanoski, the Horizons Living and Rehab Center. Is there anybody here for the complainant?
Yes, my name is Peter Rice and I represent Angela Verge.
So 10 minutes, though I do encourage you to use less than that, Mr. Rice.
Thank you. And thank you for waiting this out. Angela Verge is a 42-year-old woman with severe disabilities who was a resident at Horizons nursing home. It's a nursing home. The date of the alleged discrimination on the investigator's report is May 7th, 2020. That is not accurate. That merely is the first day of discrimination. The discrimination continues. It continued through June, July, August, September, October, and it continues to this day. And that's important because of the incidents being reported of COVID-19 significantly reduced during that period. Ms. Verge could have been accommodated because the issue is reasonable accommodation under the Maine Human Rights Act, the Fair Housing Act. And Horizons had a duty to accommodate Ms. Verge. Now, then, the United States Center for Disease Control and Prevention, the U.S. Centers for Medicare and Medicaid, as well as the state of Maine in a FAQ, all outlined how an individual could be admitted or readmitted to a nursing home. And these were issued back in March. So back during the the spring height of COVID-19. But they all outlined how someone could be accommodated, how someone could be returned or admitted or readmitted to a nursing home. Horizons did none of that. And what they're alleging is that she presented a danger to other residents. I mean, that's essentially a direct threat defense. However, Horizons is not entitled to that defense. Direct threat defense requires that Ms. Verge be individually assessed. They just can't rely on their blanket policy. Horizons never assessed Ms. Verge. And had they done so, they would have learned that she tested negative for COVID-19. And so that she did not pose a threat to other residents. She could have been admitted, readmitted. And when the United States CDC, CMS, and Maine, the state of Maine all say the same thing, that somebody can be readmitted without endangering the health or safety of others, I mean, that's true. It's pretty persuasive evidence. True, those are guidances, but I mean, we're talking US CDC, we're talking CMS. Those are authoritative government agencies who are well aware of the risks posed to nursing home, well aware of who nursing home residents are, and Horizons' failure to undertake to assess Ms. Verge, undertake to accommodate her and readmit her, because she could have been readmitted. She could have been quarantined for 14 days and assessed before she came in, tested before she came in. She would have tested negative, quarantined for 14 days, tested after that again, and she still would have tested negative and then readmitted into the general population. I'm not sure of the exact nomenclature here. But so Horizons failed to accommodate her when they had a duty to do so. Thank you.
That was spectacularly brief. Thank you, Mr. Rice. Questions for Mr. Rice, Commissioner Whitworth?
No questions.
Commissioner Ashby?
Yes, Attorney Rice, you made it seemed like a concession in your oral comments just now that wasn't present in some of your written comments, and that is those CDC recommendations are guidance, not protocols, correct?
Yes, they are clearly labeled on the front page as guidances.
And at the time of the refusal to readmit this patient, was the nursing home admitting anyone else from the community?
Not to my knowledge, no. Although I did learn that Ms. I guess this isn't included, so,
Please do keep to the existing record.
Excuse me?
You sounded like you were going to offer something that may not be in the record.
Right. That's what I was going to do.
And at the time of the refusal to readmit her, was the nursing home admitting individuals from the hospital?
I don't know the answer to that. They told the family, they told me that Ms. Verge would have to, if she went to the hospital, they would consider readmitting her. But I also want to make the point that it's not just in May that we're talking about. We're talking about June, July, August, September.
If it's in the record, in June, July, August, or September, was this nursing home admitting folks from the general population? from the
No,
community?
but what the allegation is, Ms. Verge is an individual with a disability, and they could have accommodated her by modifying their policy, and the failure to do so is discriminatory.
Okay, I have no further questions. Thank you.
Mr. David?
No, no questions.
Thank you. Hold on. We just FYI, complainant has about 5 minutes left, though there is, of course, no need to use all of them after we hear from respondent. Mr. Taylor.
Thank you, Ms. Nearson and commissioners. I'll try to be brief like Attorney Rice, as I know that the quorum horizon is looming. Investigator Brindley conducted a very thorough investigation of a fully developed factual record here. She evaluated the facts, the documentation, the shifting regulatory landscape brought on by the pandemic, including how it's really ravaged nursing homes and long-term care facilities like Horizons across the state of Maine. And when we look at the objection to her findings in her report from November 25th, it's relegated to 9 pages of cut and paste from guidances at the federal level and FAQs. And Attorney Rice referenced that, and Commissioner Ashby focused right in on that. And from our perspective, what we have not heard, and I think the investigator did an excellent job of focusing on what are the realities in this particular long-term care facility in Brunswick, Maine, that has a license for 65 residents. And to suggest that there's continuing discrimination and that this pandemic has actually abated during June, July, and August is really to entertain a fiction that just cannot be supported under any analysis. The question about community admittance, our medical director, Dr. Michael Byther,
Please don't use the names. Sorry, Mr. Taylor, please don't use the names of any
I
individual.
apologize, Executive Director. Our Chief Medical Officer on weekly meetings analyze the situation. We all know that the folks that tend to be in these facilities across the state are a cohort of very high-risk individuals, as well as the frontline workers who are focused on rendering care. I mean, full lockdown situation. There have been no community admissions in the Horizons facility, and all the way through the pandemic, and it stands today, this morning. And that's consistent with many other facilities across the state of Maine. One thing that's really important that bears emphasis here is that Miss Verge was, who has a debilitating disease, was with us, and we were caring for her for 3 years, since 2017. When her parents did not like the visitation mandates that we had with respect to no direct contact at the onset of the pandemic, they approached Peter Davison, our Chief Administrative Officer, and said, we want to take her home. We want to exercise our right to bring her home. We accommodated that within 24 hours. And ultimately, the documentation that the investigator trained on was, did they make an informed decision to take her out of the facility? And they did. And our team looked at them and said, look, this is changing rapidly. We don't know if there's any guarantee of readmittance. We want you to really think about this, because if we have no community admissions based on a decision to protect the residents, ultimately to protect the frontline workers here, we might not be able to accommodate a readmittance. We've been uniform in the policy. It's been consistent with the CDC. And one of the things that I'd like to focus on right now is, what does the CDC of Maine actually say with respect to facilities like Horizons? What it says is, specifically, here in a perfect world, we can try to accommodate, but guess what we're going to do? Because it's not a one-size-fits-all analysis. You might have a 1,500 bed facility. You might have a 65 bed, small bed facility in Brunswick. It is up to the facts and circumstances that are present at that particular facility. The record establishes an abject lack of PPE for this facility, unrebutted. The medical director has communicated in no uncertain terms repeatedly and under oath, this is absolutely necessary for no community admissions. And guess what? It's worked for this particular facility. So this notion that it's easy for us to do this because the US CDC has said you might be able to do it if you establish a separate wing or facility is just not transferable here. We do believe that Investigator Brindley did a very thorough job. And when you look at the findings, they didn't even get across, the line of scrimmage with respect to a prima facie case. They didn't establish on any level that they had a valid case. And even if they did, the request is not a reasonable one in light of the throes of the pandemic and the nature of the facility and its size. So we would ask that the commission uphold the investigator's report on a no reasonable grounds finding. Thank you.
Also excellent and short. Thank you. Questions for Mr. Taylor? Commissioner Whitworth.
No questions.
Commissioner Ashby.
Yes, I just want to take issue with the not getting past the line of scrimmage. My understanding of the case is that the complainant said that look, mom's not doing, or grandma or whoever is not doing real well. Complainant's not doing well right now as a function of her disability because of these rules, and we need this reprieve from this isolation. That's the accommodation that was actually requested, correct? I mean, you agree that that's the accommodation that was requested, right?
No, we do not agree with that, Commissioner. What the issue was they had expressed multiple complaints with respect to having not having direct contact visitation with her. She was in an end of life situation, and we accommodated the visit when she was at end of life, as we had done early in the pandemic with individuals who we thought were struggling and only had a few days left. When they asked to continue those visitations, and when she was deemed to be not in an imminent scenario, we said, look, for the safety of everybody, we can we can do video, we can do behind glass, we can make these other accommodations that are consistent with the safety of all the residents. That's when they came to us and said, well, this is not consistent with what we want. We want to take her out. So there was never a request. It's not been briefed that way. It's not been viewed that way from an investigative standpoint. And ultimately, we accommodated the request to remove her immediately from the facility.
Okay, Mr. Rice may or may not agree, I guess, with what the accommodation requested is, but in any event, it's your position that it's the safety, the direct threat or threat of harm issue that prohibits your readmitting this former client, correct?
That is correct. And like the investigator found that the Horizon stopped allowing admission from the community to limit the threat of the pandemic. I mean, and it's a metaphysical truth with respect to nursing homes. They've been hit particularly hard in our state and with a high risk population. And the initial finding by the investigator is it's not reasonable to expect Horizons, in light of its resources, the lack of PPE, to readmit her after she voluntarily was pulled out. We let the parents know that this was a risk. They had it in writing. We communicated to them multiple times to really think about this, because we couldn't guarantee what that landscape would look like in a lockdown. So this was happening all as that was underway.
Right, but this isn't a moral hazard case, right? I mean, if it was safe to readmit her, that was part of the accommodation that was requested, and I know you disagree about that, you would have to under the law, correct, if it was safe to readmit her?
Yeah, and yes, we've actually tried to work with the parents with respect to getting her back in when the community-based admissions are allowed.
So is it the case that hospital-based admissions were allowed during this time?
Yes, certain hospital-based admissions were allowed.
What's safer about the hospital-based admissions?
Based on the laboratory conditions and the PPE availability. So for example, in Ms. Verge's case, she needs to be aspirated. There's quite a bit of medical attention that she needs. If she's at home with hospice care or other social workers or people supporting the family or family visitation, that's much less likely. That's much more likely to cause transmission under certain C-19 protocols than you would, let's say, if she was receiving treatment at Maid Medical Center and transported direct and you were allowed testing on site. So, and I don't feign to know I don't have a medical degree, but talking to our chief medical officer, that's what was confirmed.
Okay, thank you very much.
Yep.
Commissioner David?
No.
Okay, thank you. Mr. Rice, you have 5 minutes left. Please feel free to use less than that. Wait, you're muted. Hold on, you're muted. There you go.
Okay, thank you. Yes, I will use some of it. The whole issue of PPE came up in the spring. That's when that issue was raised. There was no discussion, no evidence, nothing about the availability of PPE during the summer and fall when the incidences of COVID-19 were significantly less than they are now, and less than they were in the spring. Mr. Taylor said, one size does not fit all, and that's true. But an essential element of a direct threat defense is an individualized assessment. That's what takes it out of the one size fits all. Someone claiming that has to do an individual assessment to determine what the risk is. In this case, there was no assessment, no determination of the risk, just a blanket policy, which is not permissible to claim under the direct threat defense. Moreover, during the, I submitted testimony from a Dr. Donahue, who was a physician in a neighboring nursing home, who did testify at the DHHS administrative hearing that he had admitted individuals with COVID-19 to the nursing home using those CDC and CMS protocols, and there was no problem. So, and then, oh, by the way, Ms. Verge is Miss Sanowski's daughter. She's 42 years old. And in terms of the visitation, I mean, Horizons was being unduly restricted. They were interpreting, as I think many places were, compassionate care to mean end of life, synonymous with end of life. And that was based on the CMS guidance and CMS and CDC guidance. Later on, the CDC issued a FAQ, was not on letterhead, that made it clear that compassionate care was not limited to end of life situations, that it was any time that the person was in danger of their health, was in danger because they weren't having you have to look at it from the point of view of the individual in the nursing home, not access to the parents, not access to the guardian, but what is compassionate care for the individual who is in the nursing home, and having access to her parents, because she almost died a couple of times, but when her parents came to visit her and were allowed in, she recovered. The feeling was that if that, and then Horizon said, no more, because it was not end of life. And as we know now, subsequent, because the FAQ came out in, I forget when it came out, but it came out during the pendency of this, that compassionate care was not synonymous with end of life. So for these reasons, I believe that the commission should vote to overturn the investigator's report. Thank you.
Thank you. Follow-up questions for Mr. Rice, Commissioner Whitworth,
No questions.
Mr. Ashby?
Questions, thank you.
No.
Nope. Okay, thank you. Mr. Taylor, you have 5 minutes. Should you want to use them?
I think we're all set. My concern is that the focus here is on this notion of the point of view of the individual, and what seems to be lost in the communications from Mr. Rice. And I understand he's in a role of an advocate here, but we're dealing with issues of all the frontline workers, all of the other individuals or high-risk individuals in the facility. And when we look at the legal standard here, and he keeps saying direct threat and individualized assessment, before we even get to a direct threat analysis, you ultimately have to establish a prima facie case that ultimately the requested accommodation was reasonable on its face. And so when we don't even get to that analysis, we've offered that. When you look at the investigator's report, on paragraph 5 and 6, it says complainant failed to make a prima facie case because her requested accommodations were not reasonable on their face. And then obviously the facts that have not been rebutted get identified. And assuming if they made a prima facie case, we've successfully demonstrated that allowing the complainant readmission under the circumstances of this case, and we're dealing with extreme circumstances. We're in a global pandemic with a high-risk population, and it hasn't abated. This notion that June, July, and August was somehow this great time to start bringing people back into nursing homes from community-based populations. It's just not true. So from our perspective, we think the analysis is sound from a regulatory standpoint. It's not predicated on guidance or FAQs. And we think that the factual record's really fully developed. So I think we have no more comments.
Any follow-up for Mr. Taylor, Commissioner Whitworth?
Nope, thank you.
None, thank you.
Commissioner, okay. Ms. Brindley.
Good afternoon, everyone. I just want to state that this was a very sad, very unfortunate situation, but it just didn't arise to the amount of discrimination. The reasonable accommodations that the complainant requested were not reasonable on their face. So my recommendation remains. If you guys have any questions for me, I am open to them.
Commissioner Whitworth? Nope. Commissioner Ashby?
No, thank you.
Commissioner David?
No, and I will make the motion that we find there's no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability.
Second.
Been moved and seconded. Any discussion?
Very briefly, I'm not sure, it might be semantics. It may be that an actual prima facie case was made and that I interpret this case to be the request to allow this hiatus and to allow the return of this resident to the nursing home, and that return was denied. I place no significance in the fact that the respondents' relatives were warned. I don't think that's really helpful because if otherwise the duty existed, they would have to fulfill that duty. But I am moved by the finding of the investigator that respondent successfully demonstrated that allowing complainant readmission under the circumstances of the case would amount to an undue burden. Now, I don't know if that means that it's not a prima facie case. I think it's more that, well, maybe that is what it is. But in any event, I'm moved by that finding, and I agree with that finding.
I don't think that we get to an individual assessment in the face of the global pandemic and the dangers and the policy, which were universal. Her disability at that point, when she's out, she's a community member, and everybody knew what was happening. That's all.
So it's been moved and seconded. All those in favor of a finding of no reasonable grounds to believe unlawful discrimination occurred, commissioners, all those commissioners in favor, please raise your hand and say yes.
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 1, 2, 3. The finding is unanimous, no reasonable grounds. And now our last case.
Aha.
Get to if it kills me. Deb, will you do the honors? This is a reasonable grounds case.
So H20 versus or -0373, reasonable grounds, Seth Adams v. Deborah Libby. Is there anybody here for Deborah Libby?
I'm here. This is Deborah Libby.
Thank you for your patience throughout this entire day, Ms. Libby. We appreciate it. You have 10 minutes. I'm going to encourage you. I'm sorry.
I said you're welcome.
Okay. I'm going to encourage you. Don't feel the need to use all 10 minutes, but go ahead.
Well, thank you for the opportunity to speak. You're in receipt of my appeal, and I would expect that you've all read it. But I'm troubled by the written findings of the investigator because they ignored my defense and all the documentation about the dangerous act against the other tenant, theft of services, and protecting the rights of the other tenants. Kind of cherry-picked 2 portions of text that were out of context, and there were voluminous amounts of text back and forth. The complainant also made a complaint to HUD, which was supposed to be taken care of by this, and it was of rent arrears, which was fraudulent. They'd never had previous to the complaint been in arrears, and it wasn't addressed in the investigator's findings at all. And, please be assured that any other tenants engaging in any of these contract violations that the number 2 tenants, an invitee or whatever she was, these contract violations or aggressive, dangerous acts against other tenants would have been given notice to quit just to protect other tenants' rights as well as my own. And that was the reason that these tenants were given notice to quit. And I'd like to reserve my time, and I'd be happy to answer any questions.
Thank you. Any questions for Miss Libby? Commissioner Whitworth?
No questions.
Commissioner Ashby?
I don't think so. Thank you.
Commissioner David?
No.
Okay, you will have time once we hear from complainants. So I'll ask you to hold on, Ms. Libby, and we'll turn to Ms. Ender.
Thank you, commissioners. Good morning. Thank you, Ms. Nearson. So Ms. Libby has pointed out, she has shown how she lacks credibility, even in the brief time that she spent speaking to you. She talked about theft of services, both in her written response and right here. There is no theft of services, that's a crime. What she has is saying that one of the tenants, Mr. Adams's roommate, had a guest who was there to off and on to help him post-surgery, and guests are allowed under the lease and under various provisions. The law court has said that the right of a tenant to have visitors is a fundamental right, so fundamental it does not need to be reduced to writing. That's in State versus DeCoster, 653 A. 2nd, 891 from 1995, footnote 1. So theft of services has nothing to do with this. Seth had legitimate guests and his roommate had legitimate guests. There was no violence. That whole scenario about driving the way that she says he did is in the same nature of alleging that having a guest is theft of services. It's an overstatement. It's a wild exaggeration. It's inflammatory and unfair and unreasonable and not true. She had just said right before this, she had texted to Mr. Adams, "Thank you for always being so easy to get along with." He had been there for a year without problems from any other tenants, from any other guests. He conducted his life in a normal, simple, straightforward way. He's pretty reserved, as was his roommate, who has not been there for a long time now, partly because of this whole mess. So there was no attack on another tenant. There was stress there. His roommate stopped paying his share of the rent and they worked that out. So there was really no reason for this eviction other than the retaliation for requesting the service animal. So he made the request around July 29th. So he'd lived there for a year. He made the request around July 29th. He sent in 3 letters of support for his request, one on July 14th, one on July 29th, and one on July 31st. The one on July 31st, she agreed was adequate. He sent the original of that letter of support along with the rent check by certified mail on August 4th, 2020. It got messed up with the post office. She was angry that she had to go to the post office to pick it up. The investigator made a reference to that remark that she made about that. But so by October 4th, by October 10th, she had all the rent. So there's no non-payment of rent. That's another one of her exaggerations. So there was, and she had the the third of 3 copies of letters supporting his need for an assistance animal. He has a per se disability under the commission. He's got diabetes. And in fact, this animal who you see, who's in that little picture there, that's his dog, Alpine, is just a very sweet animal and very beloved, and has had this amazing, wonderful effect, exactly the reason that assistance animals are necessary. He has he's lost a lot of weight because he exercises the animal. He's much happier. He's just doing better, and the animal has served its purpose beautifully. The rent was all paid up. She was wrong to refer to there being a lack of payment. He was completely paid up. So in any event, there's her objection to the report is not fair, is wrong, and the investigator's recommendation and report should be upheld. Thank you.
Thank you, Ms. Ender. Questions from commissioners for Ms. Ender? Commissioner Whitworth?
No questions.
Commissioner Ashby?
None, thank you.
Commissioner David?
No.
Okay. Going back to Ms. Libby. Ms. Libby, you have 8 minutes. If you want to use them, feel free not to, or to use a lesser amount of time.
Well, in response to Ms. Ender, she said that I received one dated the 14th, but I received that on the 29th. So this is all very tight and close, and I don't have any problem with support animals as long as I can get a PCP note that agrees with the law, which in turn gives me protections if something goes wrong with that animal. The animal was never a part of the reason for giving the tenants a notice to quit. And I never claimed that they were behind in rent because they'd always been current. So that's not an issue.
Are you finished presenting, Ms. Libby?
I suspect so.
Okay. Any follow-up questions for Ms. Libby? Commissioner Whitworth?
No questions, thank you.
Commissioner Ashby?
I think not, thank you.
Commissioner David?
No.
Okay, Ms. Ender, I just forgot to write down how much time you had left. I think it was about 5 minutes.
I have nothing further to add, thank you.
Perfect. That's my favorite kind. Okay. So then we turn to the investigator. Back to Ms. Brindley.
Hello again. Still me, Alex Brindley, investigator of this case. I don't really have anything else to add, so if you have any questions, feel free.
Questions for the investigator, Commissioner Whitworth.
No questions, thank you.
Commissioner Ashby.
I do really quickly. So I hear the respondent essentially saying, I have no problem with a person having an assistance animal, they just need appropriate documentation. Fair enough, if that's true. And my understanding is at the time of the August 10, I'm sorry, I'm looking, I want to make sure. The August 10 discussion about an eviction, the respondent was claiming that she still didn't have appropriate documentation. And I understand from your findings that on August 11, the respondent must have received that request because she granted the request for an assistance animal. But am I correct to understand on August 12th, she still indicated she was pursuing an eviction?
That is correct. So this timeline was a little bit confusing. So I believe on the 10th is when the complainant sent out his final doctor's letter via certified mail. She received it. The respondent received it on the 11th. The complainant then asked her if the the notice to quit was still in effect, and she said yes.
Okay, that's all I have. Thank you.
Commissioner David?
No.
Okay. In that case, we've heard from the parties, we've heard from the investigator. Is there a motion?
I will move to find that there are reasonable grounds to believe that we uphold, the findings of the investigator. There are reasonable grounds to believe that the respondent retaliated against the complainant for engaging in MHRA protected activity, and that conciliation should be attempted in accordance with the act.
Second.
It's been moved and seconded to find reasonable grounds to believe unlawful retaliation occurred. Is there any discussion among commissioners?
It's kind of a textbook case of
Yeah.
retaliation. It's really not a close call.
Concur.
All right then. All those in favor of a finding that there are reasonable grounds to believe unlawful MHRA retaliation for MHRA activity, raise your hand and say yes. I
Yes.
see one,
Yes.
2, 3. The finding is reasonable grounds to believe unlawful retaliation occurred. The commission will send the parties and council a letter outlining the finding and the next steps in our process. And thank you for your patience today. Commissioners, if you can stand it, we do have one litigation matter for executive session. It also can be put off until the next meeting if it needs to be. Up to you.
No, I've still got a few minutes to do it. I'm sorry to push us along for my 2 o'clock problem, but I read the litigation memo. I think we can deal with it.
All right, so then we need
Yeah,
a motion to go into executive session.
So moved.
Second.
All those in favor of going into executive session among commissioners, raise your hands. 1, 2, 3. All right, I neglected to do breakout rooms, but I'm going to right now make that happen. 1, 2, blah, blah, blah. Okay, I'm going to take us into the executive session room, and other folks can stay on the line or not. We will be back after executive session. Okay, so we're back. We 1, 2, 3. All right, commissioners are all back. Barbara's back. Mel's back. Okay, so we would be looking at this time for a motion about the litigation in E180411.
I couldn't find my mute button. I'm sorry. I move that we accept the recommendation of council that we do not litigate the case referenced in the litigation memorandum, which you just said the number. I'm sorry, Amy. E180411A/B.
Correct. Thank you. Is there a second?
Second.
Okay, it's been moved and seconded. All those in favor of not litigating E180411? 1, 2, 3. Barbara, you don't get a vote. Okay, that motion passes, and I believe that's all we have. And I thank you all for working hard to get through all the cases. Here's to a better year this year than last.
Thanks, everybody. Have a good month.